Prayer this morning will be offered by the good delegate from Baltimore County.
Thank you, Madam Speaker. This is a prayer that my family has been doing for the last 25 years or so, maybe even longer, 30 years. Every time we get together on special occasions and on special holidays, and in the coming days we have Passover and other holidays, and I thought everybody can think about this as we go. We thank you, God, for our families both here with us today and those who are in their own homes in nearby cities and distant cities. We remember with love those who we miss daily. We are grateful for the bonds of loyalty and affection which sustain us and which keep us close to one another no matter how far apart we may be. We thank you for implanting within us a deep need for each other and for giving us the capacity to love and to care. Help us to be modest in our demands of one another, but generous in our giving to each other. May we never measure how much encouragement we offer. May we never count the times we forgive. Rather, may we always be grateful that we have one another and that we are able to express our love in acts of kindness. Keep us gentle in our speech. When we offer words of criticism, may they be chosen with care and spoken softly. May we waste no opportunity to speak words of sympathy, of appreciation, and of praise. Bless our families with health, happiness, contentment, and joy, and grant us the strength to continually build a home in which your Spirit will always abide. Amen.
Amen. Quorum call.
Madam Speaker.
Has everyone recorded their presence? So the clerk will take the call. There being 126 members present, the House is now in session. The clerk will read a journal from the previous day.
Annapolis, Maryland, March the 31st, 2022.
Recognizing the Deputy Majority Leader.
Thank you, Madam Speaker. So much be considered the reading of the journal.
So ordered. Petitions, memorials, and other papers. Yea and nay. Consent calendar 10. House bills passed in the Senate. Clerk will read the first bill.
House Bill 21.
Recognizing the Majority Leader.
Thank you, Madam Speaker. I move that the reading of House Bill 21 be considered the reading of all the bills on the calendar.
So ordered. Message from the Senate. Consent calendar number 54. Senate bills introduced in the House. The clerk will read the first bill and committee assignment.
Senate Bill 98, Senator Carrozza, House Rules.
Recognizing Majority Leader.
Thank you, Madam Speaker. I move that the reading of Senate Bill 98 be considered the reading of all the bills on the calendar.
Hearing no objections, the bills are read the first time and referred to the appropriate committee. Report of the Committee on Judiciary. Report number 40. Clerk will read the first bill.
House Bill 1456, Dorchester County Orphans Court Salary and Expense Allowance of Orphans Court Judges. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
Senate Bill 906, Carroll County State's Attorney Restrictions on Practice. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk will read the next bill.
Senate Bill 950, Wacomico County Orphans Court Salary of Orphans Court Judges. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk will read the next bill.
Senate Bill 988, Dorchester County Orphans Court Salary and Expense Allowance of Orphans Court Judges. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Report of the Committee on Judiciary, report number 41. Clerk will read the first bill.
Senate Bill 172, Department of Juvenile Services, Facilities, J. Deweese Carter Center, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 203, Children in Need of Assistance, Custody and Guardianship and Review Hearings, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 216, Evidence, Approval of Breath and Blood Tests for Alcohol, Drugs, or Controlled Dangerous Substances, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Report of the Committee on Judiciary, report number 42. Clerk will read the first bill.
Senate Bill 38, Public Safety, Fire and Rescue, Veterinary Care of Retired Fire and Rescue Canines, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read the next bill.
Senate Bill 649, Frederick County, Disposition of Marriage Ceremony Fee, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Report of the Committee on Judiciary, report number 43. Clerk will read the first bill.
Senate Bill 74, Circuit Court Clerk's Salary Increase, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read the next bill.
Senate Bill 232, Register of Wills, Maximum Salary Increase, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Report of the Committee on Judiciary, report number 44. Clerk will read the first bill.
Senate Bill 151, Hate Crimes, False Statement to a Law Enforcement Officer, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read the next bill.
Senate Bill 280, Temporary Protective Orders, Electronic Filing and Video Conferencing Hearings, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read the next bill.
Senate Bill 775, Courts Payment for Jury Service, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Report of the Committee on Judiciary, report number 45. Clerk will read the first bill.
Senate Bill 614, Criminal Law, Controlled Dangerous Substances, Schedules, Adjustment, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read the next bill.
Senate Bill 878, Maryland Trust Act, Trustee Liability, Released by Interested Parties, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Report of the Committee on Judiciary, report number 46. Clerk will read the first bill.
Senate Bill 36, Wills and Trust Instruments, Electronic Execution, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read next bill.
Senate Bill 468, Estates and Trusts, Personal Representatives, Payment of Commissions and Attorneys' Fees without court approval, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read next bill.
Senate Bill 508, Estates and Trusts, Guardianship of Minors, Appointment by Court, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Are there any amendments? Ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed. Passed for third reading. Clerk will read next bill.
Senate Bill 694, Estates and Trusts, Guardianship of the Property of Disabled Persons, Court-Appointed Attorneys, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered passed the third reading. Report of the Committee on Judiciary, report number 47. Clerk will read the bill.
Senate Bill 20, Criminal Procedure, Out-of-Court Statements, Child Victims and Witnesses, favor the amendments. Amendment 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
The amendment is technical in nature and conforms the bill to HB 284, which was passed out of the House earlier this session. Please move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered passed for third reading. Vetoed House Bill Calendar Number 2. The clerk will read the bill. That's not it.
House Bill 90, State Personnel Management System, Office of the Public Defender, Placement and Collective Bargaining. That's what we just did. We just did already. That's all right. Let me read it again. House 190, State Personnel Management System, Office of the Public Defender, Placement and Collective Bargaining.
HB 90 has been vetoed by the governor. The question before the House is, shall the bill not pass, notwithstanding the objections of the chief executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto.
Madam Speaker.
Gentleman from Eastern Shore, Frederick, I'm sorry.
Thank you. So I rise in support of the governor's veto. I ask my colleagues to sustain the governor's veto, and I do so for a couple reasons. One, the role of the Office of the Public Defender is critical, and it's in our Constitution. You have a Sixth Amendment right to counsel for indigent individuals, and public defenders are there to ensure justice is served for our citizens across our state. The concern I have with this bill is that the focus now is going to come off the client and onto the public defender. That's the concern. Matter of fact, when you looked at the announcement of OPD, when they announced that they wanted to unionize, they wrote, the lawyers and their staff said unionizing will help ease the challenges of enormous caseloads and improve working conditions. When they say caseloads, they mean clients. They mean Marylanders. They mean citizens that need their help, and they want to reduce the workload. Unfortunately, justice doesn't stop. We need public defenders to work, we need them to do their job, and we need them to stand up for justice, and unionizing is just going to probably get in the way of that. Thank you, Madam Speaker.
Madam Speaker.
Gentleman from Montgomery.
Thank you, Madam Speaker. I rise in support of this bill, and I want to thank my good friend, the delegate, for bringing it forward. I think we talk a lot about the role and responsibilities of public defenders, but what we don't talk about is who's taking care of the public defender, as the public defender is taking care of the indigent and those who require representation in our criminal legal system. We know, this is not according to me, that public defenders' offices are underfunded compared to prosecutors. The caseload, the clients that they receive are certainly higher than what prosecutors, assistant district attorneys receive. And that places an imbalance within our criminal legal system, but particularly for those, the indigent, that require representation. This bill is about centering the public defenders who have been doing the work, but often have not been receiving not just the representation that they deserve in the workplace, because this is a right. We're talking about the right to collectively bargain. This is not new. This is in something that is codified in the United Nations. This is something that we talk about often at the federal and at the state level. The right for workers to decide whether they want to organize and to form a union, and this is what it would help get us there. And so this is about public defenders, but it's also about our criminal legal system. If we allow for greater participation in the workplace, and if we allow for public defenders to not just have the rights that other workers have, we're making the workplace a better place, not just for public defenders, but for prospective public defenders, because we know that it is hard in order to attract and retain good lawyers in the office of the public defender. This bill will help with that in so many ways. And so I think the governor's veto was very misguided, and I'll be proudly voting green to override. Thank you, Madam Speaker.
Young lady from Hartford.
Thank you, Madam Speaker. I read the governor's veto message, and I found it absolutely fascinating. And let me tell you why I found it so fascinating. There was a letter written by the public defender, the head public defender, Paul B. DeWolf, who has been public defender for many, many, many years. And he stated that the legislation will change the character and operation of the Office of the Public Defender in fundamental ways that will adversely impact our ability to recruit the most promising assistant public defenders and provide representation that is solely focused on the interests of our clients. Having been in the House Judiciary Committee for, this is the 20th year, and having gone through the death penalty arguments, I will say that the public defenders have probably been the most vigorous advocates for the positions of their clients in the public defender's office. They do an excellent job, and contrary to what everyone says, they are really attorneys. And when the private bar has criminal cases, they will consult with the public defenders because they're the ones that are in court the most time. And I think that the fact that Paul DeWolf does not want this bill says volumes to me. This is somebody that is a truly dedicated servant, and that just surprised me, and I think that he's on the right page. You don't want to get ensnared and have people working that have all these rights and benefits, and we're going to end up like the New York City teachers that are sit in a room because they can't fire them. And so I would just say we need to sustain Governor Hogan's veto. Thank you.
Madam Lady from Prince George. Excuse me, hold on a second. The Judiciary Chair.
Of course.
Thank you, Madam Speaker. I rise in support of overriding the governor's veto. Yes, ladies and gentlemen of the House, public defenders are attorneys. They are some of the hardest working people in the courthouse. Not as hard as I work, of course, but they are some of the hardest working people in the courthouse. They have to deal with difficult clients who have sometimes done terrible things. They have to sometimes deal with people who have in fact done those terrible things, and there's no help for them. So they have to stand up there with limited resources and limited time, and they have to do the best that they can. And if they want the right to collectively bargain, and if they want the right to collectively bargain their workplace conditions, I have absolutely no problem with that. And that's why I'm going to override the governor's veto.
Madam Speaker.
Madam Speaker.
Gentlelady from Prince George.
Thank you, Madam Speaker. I rise, colleagues, to ask you to override the governor's veto, and that vote would be a vote for justice. You have a constitutional right that you are innocent. Their clients are innocent until proven guilty. It takes two attorneys and a judge, and sometimes a jury, to get to that final finding. A vote for this collective bargaining is not just a vote for better work conditions, actual dockets that you can manage so you're not committing malpractice because maybe you've read the case for about 2 minutes before you're in front of an attorney, but it's a vote for justice so that everyone in our court system around Maryland, and some of us that are actually in our courts and just haven't recently been playing attorneys, can actually have a fair process and an avenue to justice. I ask you to override this veto and remember that this vote is a vote for justice in Maryland. Thank you. Thank you, Madam Speaker.
Gentleman from Frederick.
Thank you, Madam Speaker. Would the floor leader rise for a quick question?
Yes, sir. I'm right here.
Yes,
Thank you.
floor leader.
Good morning, and I'm wondering, should the public defenders organize and then go on strike? What is the remedy for those who are in jail and don't have representation? What would happen in their cases?
Well, let's see. Stand by. Gotcha. Yeah, under state law. That's correct. Yeah. Understood. So under state law, and I'll also feel free for my friends from the Judiciary Committee to also stand up on this, but under state law, public employees are not allowed to strike. They can go through other means of having their issues redressed and in committee. Excuse me, I'm just listening to my co-pilot here. But yeah, and in terms of state law right now, they are not allowed to go on strike. They can go to arbitration and continue to bargain, but they can't go on strike.
So if they were to go on strike,
They cannot go on strike.
As have, you might recall the days of in the 80s when the airline industry did so. So if that were to happen, the governor could fire them. Is that true?
Could the governor fire them?
They can't go on.
They can't go on strike. There's nothing to fire.
So if they decide to not show up to represent someone in jail because there's a negotiation they're not happy with, I mean, what's the point of collective bargaining?
If an employee chooses not to show up to work over a certain period of time, they would be subject to the normal repercussions associated with not showing up to work.
So then they could be disciplined and potentially terminated. Thank you, Mr. Floor Leader. I appreciate it. Delegate. Here's my concern. This is one of the first times that I think that we've seen the public defender come in and say that this is not a good policy and that we as Republicans and we as people who defend the innocent are concerned that it could impact those who have a constitutional right to representation. If your focus, as we've just heard, is on collective bargaining and negotiating, your focus is not, therefore, at that moment on representing those sitting in jail like they've done many times the last 2 years without trial, with suspense of jury trials. And then you have their only attorney in the middle of a collective negotiation, this is a concern. I think it's not properly reviewed, and I'm not so certain. It took you a while to look into the legality of strikes for public employees. I'm not so sure you're necessarily correct on that, but in any case, I believe we should sustain the governor's veto. Thank you.
Madam Speaker.
Madam Speaker.
Madam Speaker.
Who was up first? Gentlelady from Anne Arundel.
Thank you, Madam Speaker. Thank you, colleagues, for carefully considering this bill. I did just want to clarify that the public defender did not submit testimony on this bill. All the testimony that was submitted was favorable testimony, and there was a letter of information submitted by the administration, but there was no testimony from the public defender. I'd also like to say that nothing should come between an attorney and their client. That relationship is so sacred that the communication must be kept secret. It's similar to a relationship between a person and their priest and a husband and their wife. It is treated the same under the law. An attorney and their client is treated the same. The system that we have now, we have a public defender, and each of their attorneys are assistant public defenders, and they serve at the pleasure of that public defender. That means that their work product, the quality of it, is measured by that public defender, not the person standing at trial table to their right, whose constitutional rights, whose freedom, and whose liberty is on the line, but the public defender gets to measure the efficacy of their work. This bill would sever that bureaucracy between the public defender and that attorney and allow their relationship with their client to be the primary relationship, as every attorney knows that it should be. If you've ever consulted with an attorney and relied on their advice, imagine if that attorney was giving you advice that was based on the viability of their job and not the viability of your case. So I would ask that everybody override this veto and treat it as you would if that attorney was your attorney and your liberty and your rights were on the line. Thank you, Madam Speaker.
Madam Speaker.
Minority Leader.
I didn't intend to speak, but I think that argument exactly shows why this is bad. I've worked for other attorneys. I worked at some very large law firms, and they assigned me to go work for a client. They assigned me. It really wasn't my client. My client didn't choose me when they hired McGuire Woods, Battle and Booth in Richmond, Virginia. They hired the law firm, and someone said, you go help them with the work. And you know who knew whether I was doing a good job or a bad job? Probably not the client who hired the law firm because they really didn't understand the law or whether the person was making the right arguments or the wrong arguments or was doing a good job before the judge of the deposition, because they weren't lawyers. My superiors, my bosses, the people who hired me and evaluated me, they knew whether I was doing a good job or not. They could read my work product. They could evaluate me in court. They could ascertain whether my results were in line with what other similarly situated attorneys were getting or not. It's not the person. When we say that these criminal defendants hired that public defender in that sacred bond, I think any of us that have ever worked in this system know 9 times out of 10, the day that the criminal defendant shows up, they've never met that public defender at the first appearance. They didn't hire Joe Smith or Sally Jones to be their public defender. The court told them, you have a right to an attorney. Do you have an attorney? I do not. One will be appointed for you. Mr. Jones, Ms. Smith is in the room, or the public defender's office. You go down, you meet with them, you're on a list. They don't go through the list of the 200 public defenders in a large jurisdiction and said, I heard Sally's really good, I heard Pete's not very good, I choose Sally. Some days they get Pete. And when they get Pete, they don't know if Pete does a good job or if he doesn't. But Pete's superiors should, the Office of the Public Defender should, and that's the people who should be evaluating them. And those people, because they are professionals, and their skill and their ability is so important to those clients, they should be evaluated objectively as professionals rather than simply be afforded the full panoply of union protections. There's nothing wrong with union protections. 99% of states' attorneys don't have them, so that the state's attorney can say, I don't think you do a very good job. I put you in juvenile court for 6 months, and I find out that you are pleading out a lot of cases of child sexual offenses and things of that nature that I think should be prosecuted. I'm getting rid of you, or I'm moving you somewhere else. The public defender should be able to do the exact same thing without worrying about, well, this person's unionized and they'll raise a claim against me, or they'll seek a collective bargaining right to prevent that. That's why the governor's veto was made, and I think that's why it's important. Thank you.
Madam Speaker. Madam Speaker.
Madam Speaker.
Gentlelady from Baltimore City.
Thank you, Madam Speaker. You know, this bill really is about making our justice system more just and work better. And I want to respond to what the delegate from Frederick said, because I think it's absolutely true. The focus has to be on the clients, on the caseloads. The caseloads are the clients, as he said, and that's exactly what this bill is all about. The ABA, the American Bar Association, makes recommendations every year for how many cases state public defenders should take on. Well, in some recent years, our public defenders in Maryland have had caseloads exceeding 200% of what is recommended. If any one of us ever found ourselves in a circumstance where we needed a public defender and to rely on a public defender, can any of us say we would want our lawyer who had, our freedom in their hands essentially, to be so overworked that they didn't have time to look at our case adequately? No, of course not. That's why this bill is so important, because our public defenders want to do right by their clients. They want to do the right thing. They want to have the time that is necessary to defend their clients in court to the best of their abilities each and every day. That's why this bill is so important. Reasonable caseloads for attorneys have tangible, life-changing benefits for clients. And unionized public defenders with reasonable caseloads, that means lawyers can spend the time they need on those clients' cases. Finally, I want to urge a green vote because you've all heard from constituents and business owners. We've seen the lack of staff that we need in so many of our agencies, and the public defender's office is facing that too. I've had so many friends who've been public defenders, and eventually the caseloads just burn them out and they leave. And they are brilliant attorneys, and some of them have gone on to become federal public defenders. Some of them have gone in-house and doing CJA cases. So they're doing this work, but they're not working for the state, and we want to keep them here. We want them to stay doing this really important work and making sure that our justice system works, right? That our chairman of Judiciary has a worthy foe in court, right? We want to make sure that we have the best and brightest of our public defenders. So Marylanders who rely on public defenders deserve better, and our justice systems deserve better too. That's why I'll be casting a green vote. Thank you.
Madam Speaker.
The floor leader.
Thank you, Madam Speaker. And I know the other folks are going to add to this. My friend from Baltimore City took a lot of my points, but also going back to a friend from Frederick, this is about the clients, and this is about the quality of service that they're getting from our public defenders. And the majority leader also mentioned too about concerns related to how well our public defenders are. And if they have caseloads that are ridiculously overpowering, burning folks out, then is it fair to say that someone's not doing a good job when they've been given a job that can't be done in the first place appropriately, and they have no regress to find out exactly or to work with bringing those caseloads down? Talking about collective bargaining we're going in this direction because that there hasn't been an opportunity to have these issues redressed under the current system. We're providing the opportunity and enabling collective bargaining, as we do always, so that there is a role for them to play in these questions. Are the caseloads too much? Are we providing the best service for our clients? Are we meeting the constitutional obligation of providing representation in a courtroom? And as of right now, they don't believe the answer is yes. Passing this bill, overriding this veto, gives justice back to the folks that are providing representation constitutionally to the folks that need it most. I urge a green vote and hope the body follows me.
Madam Speaker.
Gentleman from Prince George.
Thank you, Madam Speaker. Colleagues, I know many of you, this debate isn't going to change how you're going to vote, but I would ask you to take some time, it might be even after we vote, to talk to public defenders in your county, in your jurisdiction, and ask them about the caseloads that they have, ask them about why they decided to go into public service. I think there's an assumption that public defenders only represent bad guys or people who do bad things. We have a legal system that you are innocent until proven guilty. Many of these folks go into this work because they are looking for the indigent folks who don't have representation, who didn't do that bad thing, and wanted to make sure they had a fair shot in our legal system. I started my career as a labor organizer because I understand how important the workers are to the functioning of our democracy. Not just, we've been having conversations over the course of this legislative session about our healthcare workers, our teachers, and how classroom size and getting classroom size smaller improves the quality of education our students receive. Getting the ratios lower for our healthcare workers improves the quality of services that those who are sick and needing our hospitals. The same applies to our legal system. When I spoke to our public defenders over the summer about this bill, they told me about how many of them were upset with their caseloads, and they went to their supervisors about that, and many of them got punished, okay, saying that they were upset because they didn't feel like they could give the type of quality of service that they felt their clients needed, and they were punished for it. Part of this is making sure that they have the freedom, right, to make sure that they can demand of their supervisors that they get what they need. We know the challenges we have in pipelining people coming into the field. We need to get more people to be public defenders, right? We need to support them and give them the resources possible to make sure that we can get the sizes down, that they don't have to fear any type of repercussions for speaking up and speaking out about the quality of their work, but also the quality of service that we need to have for our legal system to function. So I just would ask you all, it may not change your vote, but seriously, go in your jurisdiction and talk to a public defender who represents your area and about the importance of this and why it matters so much to them. Thank you.
Okay. The question before the House is, shall the bill pass, notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Would anyone like to change their vote? If not, the clerk will take the call. There being 97 votes in the affirmative and 41 in the negative, the veto is overridden. Clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 90. Said bill is sent to you for your consideration.
Hearing no objections, the message is adopted. Calendar of vetoed House bills number 2. The clerk will read the bill.
House Bill 580, Maryland Transit Administration Police Collective Bargaining Supervisors and Sergeants.
Gentleman from the Eastern Shore.
Thank you, Madam Speaker. Could the floor leader rise? I've read the governor's letter and have some questions and concerns that I'd like to bring up.
Absolutely.
Okay. So in this bill, where are we making law change? What part of the title and subtitle are we making law change?
Sure. State personnel pensions. This is Article. Sorry, I was looking for the number you mentioned. It's under the section state personnel, section 3.
Okay, well, I was under the impression that this is actually amending the transportation article, not the state personnel and pension article.
Gotcha. No.
Okay. So, are you sure about that? I mean, because the basis for the governor's veto was, you're taking a part of the transportation article and you're amending it and creating collective bargaining, and you're doing it in the wrong place. Or do I have it wrong?
Just make sure I get an answer for you. Excellent. Nothing wrong with jumping on the gun on my part. We're just listening to our counsel, but no, you're right. It's under the transportation article.
Okay. All right.
And just to, if I could just clarify too, we're pulling from and taking language from other articles related to collective bargaining, but this is in the transportation article.
Yeah, I can't hear you. Sorry.
There we go.
Good morning.
Good morning. As you are correct, it is under the transportation article. The language being used and taken from other parts of the personnel.
So to the floor leader, I think that the foundation of the problem starts with the general misunderstanding where we would expected collective bargaining to be applied. We did something unusual in this bill, which is we went to the transportation article. Under the state personnel and pension article, that's where we have under Title III, Subtitle 4, employee organization must seek certification as an exclusive representative. An employee or a group of employees seeking an election to determine an exclusive representative for the purpose of collective bargaining, and that it must be supported by 30% of the employees in the appropriate bargaining unit. And lastly, the State Labor Relations Board determines the appropriateness of the bargaining unit. And so now that we've got this straight, I'm going to be perfectly plain with you. Why, if we already have a part of our law, code, title, subtitle that relates to this, why are we going into the transportation article for such a thing?
Want to make sure I get you an accurate answer this time. Because we're also expanding it to supervisors and sergeants.
You mean managers?
Sergeants and managers, yeah.
Okay, so why, I mean, I'm not going to say that this isn't groundbreaking. I'm sure there are examples, but
Sure.
Why are we giving managers rights to collectively bargain?
It's not groundbreaking.
Madam Speaker.
I mean, you have management and you have workers. I mean, there's a separation between the two.
They're defined specifically in the bill. What's the question? Why are we providing separation?
No, I'm asking the bill, and you're right, relates to supervisors and sergeants, and comes to a foundational conversation as to, if we're talking about the workers, that's one thing, but this is actually giving management, sergeants, and supervisors collective bargaining rights. I'll ask another question, because that's another problem with the bill. The question I have is, are all the police sergeants in agreement about being represented and having the legislature select the bargaining unit? All MDOT, MTA, police sergeants.
One more time.
Okay. We're in this bill, we are creating collective bargaining for sergeants and supervisors. Are all of these sergeants and supervisors in agreement about being represented in the way that this bill was crafted?
Are every single one of them on the same page about how this bill was crafted?
That's correct. That's a good question. That's my question.
No, it's a question, but
okay.
haven't really gone through and asked every single one of them, so to say yes would be false. So no, I couldn't possibly know, man. Delegate, my mistake.
Yeah, so I mean, of course, there is under the state pension and another part of the article, they have the ability to do this. They don't need the legislature to do it for them. And the question is, have they selected of their own volition how they want to be represented and given the opportunity to choose their appropriate bargaining unit? I'm almost done with the questions. There are some real problems with this bill, and I think we're having this conversation back and forth that are raising it, and then I'll speak to the bill.
Yeah. You're reading my mind, huh?
Yes.
You had a few more questions, Sergeant.
That's the last one.
That was the last one. Gotcha.
Yeah.
One more time, man.
Okay.
Delegate.
Managers and sergeants and supervisors have not been given the ability, through what's already in law, the ability to decide if and how they're going to create a collective bargaining unit. This bill produces this and requires it, and my question is, are the sergeants and the supervisors on board with what it is that you're doing here?
So I'll say that we're not producing anything. We're taking language that already exists, but we are enabling it for supervisors and sergeants.
Okay. Thank you, Mr. Fluter. Madam Speaker, because you and I can read each other's minds, I'm going to Sure.
One more
Of course,
time,
absolutely.
The answer was that also, yes, they did want it, but in terms of what you were stating, we're not creating it, we're enabling them to do what's already allowed to other state employees.
Okay. Madam Speaker, the problem with this bill is collective bargaining is a tool for non-management employees to have an equal footing with management in determining working conditions, including managers in a collective bargaining unit who may impact the ability to make independent managerial decisions. The supervisory exclusion of management is not limited to Maryland law. It is present in several federal laws as well, including the National Labor Relations Act and the Federal Service Labor Management Relations statute. So I stand in support of the governor's veto for reasons that he's articulated in writing for the entire General Assembly, but I believe that the debate and conversation that I had with the floor leader brings rise to some legitimate concerns and questions about where the legislature's responsibilities are in creating these collective bargain opportunities. Should we be giving these to management of these organizations? Should we, and I don't have it in front of me, should we take a Maryland Transit Administration, MTA, that already has 4 collective bargaining units, and in the place of that and or augmenting that, are we in the best position to be doing this as a legislature? The governor says no, he vetoed the bill. I support the governor in this particular policy conversation and would ask the legislature to follow suit.
Madam Speaker.
Floor leader.
Thank you, Madam Speaker. Not that it was a question, but in regards to the statements, this is the legislature's absolute role, and it is right that we should do so. We have done it multiple times before, and one from the discussion back and forth and not having understood, not having the questions beforehand, which is completely fine. The supervisors and sergeants and these folks under MTA were left out 40 years ago. This is the only instance in which we have these supervisors and sergeants. They don't have the same opportunity to collectively bargain. That's why we're doing it. It's not a microcosm of unfairness. We're doing this because they've asked for it and they would like it. It's not us stepping in to tell them what to do. It's enabling, as we always do, enabling them the ability to follow a process that almost everyone else, if not everyone else in their same positions, have the ability to do. I would encourage the body to vote to override the governor's veto and give these supervisors and sergeants who do an amazing job day in and day out and haven't had this ability for 40 years the ability to do so. Thank you.
Okay.
Madam Speaker.
Gentleman from Baltimore County.
Thank you. The question is whether they have to given an opportunity to bargain. I was reading very emotional letter here from one of the transportation supervisor. My name is Kim Harris, and I've been working as a transportation supervisor with the Maryland Transportation Administration for 19 years. My role here at the MTA is to assist the bus operator in all aspects of day-to-day transportation and efficient service and to our riding public. My job is essential for the operation of the MTA to give guidance to the operators moving customer across the city. And while on the job, I have experienced unfair treatment and bullying by management. Therefore, we need this bill because for the fair treatment, and I will be voting green on this bill. Thank you.
You're back. Gentleman from Eastern Shore.
Madam Speaker, just to close, let me just say this. My primary concern is you're amending the wrong part of the article. These employees represented by 3 MTA unions, which are the Amalgamated Transit Union, Local 1300, the Office and Professional Employees International Union, Local 2, the American Federation of State, Local, and Municipal Employees, Local 1859, Council 67, are not transportation service employees. We're in the wrong part of the law to be making these kind of decisions. Thank you.
Shall the bill pass notwithstanding the objections of the chief executive? A reminder, a green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Would anyone like to change their vote? If not, the clerk will take the call. There being 98 votes in the affirmative, HB in the negative, 40 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 580. Said bill is sent to you for your consideration.
Hearing no objection, the message is adopted. Report of the Committee on Appropriations, report number 22. Clerk will read the first bill.
House Bill 1367, Post-Traumatic Stress Disorder, Alternative Therapies Fund, Establishment, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
House Bill 1388, Winery and Vineyard Economic Development Grant Program, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past for third reading. Clerk will read next bill.
Senate Bill 437, Agriculture, University of Maryland Extension, Urban Farmer Assistance, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
Senate Bill 829, Department of Human Services, Family Investment Program, Contract and Program Review, favorable.
Question for the House is adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 911, Maryland Stadium Authority, Hagerstown Multi-Use Sports and Events Facility, alterations, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read next bill.
Senate Bill 953, Commission on African American History and Culture, alterations, Senator Verda, Welcome Act, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 1007, University System of Maryland Academic Facilities Bonding Authority, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. We're going to take a pause at this time to At this time, I want to take a moment to recognize someone who most people know. She is often the first person you see when you visit the legislative office and has been here longer than many of the people in this room. For 16 years, she's been keeping the Speaker's office moving like a well-oiled machine. She has been a driving force behind the Rules Committee. She effortlessly handles the hundreds of nominations and appointments for our office. And as one of the longest serving staffers in the Speaker's office, she has institutional knowledge that all of us have relied on. Pam Johnson has been an incredible asset to our office, and sadly, this will be her last session. Pam will be leaving us in October for a well-deserved retirement. But before she goes, I want to thank her properly for her work and service to the state. I would like to invite Pam to come up to receive a resolution. Got Jeremy moving furniture. Okay, okay. Hold on a second. Clerk will read the resolution.
Be it hereby known to all that the House of Delegates of Maryland offers its sincerest congratulations to Pamela A. Johnson in recognition of your retirement after 16 years of service to the Maryland General Assembly. The entire membership extends best wishes on this memorable occasion and directs this resolution to be presented on this 9th day of April 2022.
Literally, nothing gets past me. I don't know how this happened. Literally, I know it all. So clearly I don't from what you guys have done today. It has been a labor of love. This was my retirement job. I worked 30 years for state government, and I came here for 3 months in 2006. They asked me to stay. I said, is that an option? They said, yes. So here I am, 16 years later. These two people right here are my little people who were here with me, and they were truly little people when I came. And they are now adults, grown-ups, telling me what to do. So, and oh my God, my girlfriends are here, my traveling buddies, and my niece, and my daughter who has always got my back. But you guys, it has been great to work with you, to know you all. I know we don't all agree on everything, but for one thing we truly all agree on is to make a better life for the people of Maryland. God bless you. Oh my God.
Thank you. Okay, where are we?
Now we're rolling.
All right, we're still on.
We did the committee report, so.
Vetoed House Bill Calendar number 5. The clerk will read the bill.
House Bill 937, Abortion Care Access Act.
Question before the House is, shall the bill pass with notwithstanding the objections of the Chief Executive? Again, the green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Gentlelady from Anne Arundel.
Thank you, Madam Speaker. For centuries, science was misinterpreted or misused to ask the wrong questions, and women's brains were weighed and measured and found wanting. Part of women's allegedly inferior, deficient, or fragile biology, their brains were at the heart of any explanation as to why they were lower down on any scale, from the evolutionary to the social and the intellectual. The inferior nature of women's brains was used as the rationale for frequently proffered advice that the fairer sex should focus on their reproductive gifts and leave education, power, politics, science, and any other business to the world of men. We all know better than this today. Women have equal status to men intellectually, socially, and politically. The fact that science was used to dehumanize women for centuries is a bleak mark on our shared history, and we deserve to be ashamed of it. The inconvenient truth, ladies and gentlemen, is that full-term babies in their mother's wombs are fully formed human beings with the ability to feel pain. And the killing of these children is murder. I hear a lot about your feelings on this floor regarding different bills and amendments. I stand today because I care about the science, I care about the law, and I care about doing what is right regardless of the political consequences. A vote to override this veto is not a vote to support women's rights. Maryland already has some of the strongest abortion rights of any state in the nation and one of the highest rates of abortion in the world. A vote to override this veto is an extreme partisan move that shows that you support unscientific, false narrative that full-term human beings in the womb don't matter. Their lives don't matter, and murdering them doesn't matter. With Governor Hogan's veto of this extreme bill, we have been given a second chance to do what is right. We have a chance to correct history. Our children and our children's children need not look back at what we do today with shame and disgust. Future generations of Marylanders need not remember this body in the year 2022 as backwards thinking, science rejecting, and child murdering political body. I stand today because I argue that we are better than that. I know you are better than that. Do not double down on extremism and murder of the unborn. I promise that if you do, history will not look back on you kindly.
Recognizing Minority Whip.
Thank you, Madam Speaker. Let me just say that, believe it or not, I have no idea what the thought process is, that if there is any, regarding the veto decision-making process. And, you know, believe it or not, I'm not confided in with regard to that process. But irrespective of the inevitable outcome of the vote on this particular veto, I'll tell you that I am ecstatic about the decision to veto this one. And that's because HB 937 really represents the most radical expansion of abortion in Maryland's history, in a state that already has some of the most liberal abortion laws in the country. This bill makes insurance companies cover abortions at no cost to the patient. We don't do that for diabetes. We don't do that for cancer. And we don't do it for childbirth. But an abortion will be free. To me, that's radical. Not only that, this bill expands who can perform abortions to people like nurse practitioners and midwives and the taxpayers of Maryland, irrespective of their views on abortion, are going to pay $3.5 million a year to pay for that. To me, that's radical. Madam Speaker, this bill is too extreme, even for Maryland. I'll be voting to sustain the governor's veto. Thank you.
Madam Speaker.
Madam Speaker.
Gentlelady from Hartford.
Thank you, Madam Speaker.
Oh, Carol, excuse me.
Thank you, Madam Speaker. I stand today also in support of the governor's veto of this bill. My heart is grieved over this bill, and I have to stand today to stand up for the unborn who are unable to speak for themselves. We were told in this bill that we needed more access. Yet the research tells us that Maryland is the third easiest state in the nation to get an abortion already. There are clinics all over the state. Every geographic area is covered: Annapolis, Baltimore, Easton, Frederick, Owings Mills, Towson, Waldorf, just to name a few. We stood here a few days ago and we were told we had no money for gas tax relief. Yet we're going to spend, as my colleague from Carroll just mentioned, an additional $3.5 million a year to fund more abortions from taxpayers, many who find the procedure wrong. If we are going to spend this money, we should be doing it to save babies, to support women with challenging pregnancies. I just ask you to truly think about what we are doing and why, and I ask you to sustain the governor's veto. Thank you, Madam Speaker.
Gentleman from Frederick.
Thank you, Madam Speaker. Madam Speaker, I rise to urge the body to sustain the governor's veto. This bill does two things that are unconscionable. First, it provides training for physicians to ensure that abortion continues by our taxpayer dollars in Maryland. And second, it mandates coverage and payment in state law for what I believe is a cover-up of sex trafficking crimes, because we're the only state, let me explain why. We are the only state in the 5-state region that uses our taxpayer dollars to pay for abortions. That should not be. And so individuals are brought here from other states using your money, our money, the people's money, at times to cover up how they became pregnant and to terminate and kill the life of that little one inside of them. And that should not be. One thing we can all agree on is that taxpayer dollars should not be used for this. So I urge that we sustain the governor's veto. Thank you, Madam Speaker.
Madam Speaker.
Madam Speaker.
Gentlelady from Montgomery.
Thank you, Madam Speaker. Good afternoon, good morning, colleagues. I rise today to ask you to cast a green vote to override the governor's veto on this incredibly important bill. I have not shared this story publicly in such a large forum, but I rise both as a mother who had a very high-risk pregnancy after a failed pregnancy that resulted in a catastrophic loss, and I rise also as a sexual assault survivor. When I was in college, I was assaulted by a friend, and similar to a story that was shared on this floor when we last debated this subject, could not believe how challenging and how difficult and how incredibly emotional I felt with the weight of what had happened after that incident. And at the time, I was in school in North Carolina, and the laws there are very different than the laws here in Maryland. And thankfully, the incident did not result in pregnancy. But had it, it would have drastically changed my life if I had not been able to access the care that I needed at that time. Subsequently, I was able to go to law school and continue in a career of public service that has landed me here in this body before you today. And I'm so grateful for the opportunities that I've had because of the access to care that I've been able to have throughout. I have a high-risk autoimmune condition. I've been immunocompromised this entire pandemic. It's been an incredibly scary couple of years. This entire time, this chamber has worked so hard to keep people like me safe, and I'm so grateful for that. But as a child, I grew up in poverty. We had no access to health care. My mother was a nurse working in the healthcare field, and yet we were so poor, we could not access the basic health care that we needed growing up. In fact, I broke a finger growing up in recess. I was unable to participate in anything that my mother was worried about could happen to me that would land me in an emergency room, and yet, as a child, I broke my finger, and we couldn't go to the emergency room to get it fixed. We had to literally make a cast at home that I wore for weeks. It was made of the thickest cardboard that one could find with athletic tape and this disgusting vinegar solution to try and reduce the swelling. That's what happens when people don't have access to health care, and it has been my mission in life to work to ensure that no child, no person is left without the access to health care they need when they need it most. All I have heard on the floor thus far has been extreme examples of an extreme language. But to me, this is very simple. It is not radical to ensure access to health care when people need it. It has been my mission in life to do so. I'm so proud of this General Assembly for the thoughtful approach that we have taken on this critically important measure so that we can make sure that any human, anybody in this state who needs access to the health care that they need can get access to it when they need it most. Thank you, Madam Speaker.
Speaker.
Gentleman from Baltimore County.
Thank you, Madam Speaker. Ladies and gentlemen of the House, I don't get up and speak often, but I need you to hear my heart this morning. I'm reminded of a mother that loved her child so much that she put him in a basket and floated him down a river. And parents picked him up and raised that child. I'm reminded of a story from Einstein, the Albert Einstein, the mathematician. 7 brothers and sisters were aborted before his birth. I'm reminded of science. I'm a patient of science. I'm a product of Johns Hopkins Hospital. I was born a blue baby. Through my mother's pregnancy, I was the number 5 child. Through that time, she had a difficult time, but they didn't discover my sickness until several weeks, months later, years. But I'm a product, and we, for the past 2.5 years, we've been saying, follow the science, follow the science. Well, I believe that if you can hear the baby's heartbeat at 6 weeks, that baby's fingers are beginning to move and feel around. I believe that that baby has an option and has rights. And I believe there's health care available. But I also believe that there's adoption. There's a different way to go about this. And ladies and gentlemen, I'm pleading with you today to listen to your mother's hearts, to your own hearts, and to put a red vote to support this. And let's take a real look at this issue and come up with a real answer. Adoption. God bless you, my friends.
Madam Speaker.
Gentleman from Baltimore and Harford County.
Thank you, Madam Speaker. Before I even say anything, I just want to let you know that I pray for all you, no matter what side you're on, and that you open your heart. In a country where parents stand in line begging to adopt children, to travel over the whole world from this country to bring children back, raise them, give them love, educate them. This is the wrong thing to do. You know, everybody wants to talk about choice. There is a choice to protect yourself before it happens. Not everybody can do that, but that's a choice. Once that baby is conceived, there's only two parties that have a choice. That is the infant, and that is God. It's not in our hands. The next choice is, if the woman's not sure about this, she can receive counseling. She can save that trip to some foreign country and turn that baby over for adoption to a loving family. That's a choice. She can come to us and seek help to raise that child in her own house, because that is something that we do. We do provide for expectant mothers, and we do provide for mothers after the children are born. That's what we should be doing. Adoption Care Access Act is what it should say, but it doesn't say that. I don't agree with the governor very often. I'm not sure why he did this veto. Whether he did it for the right reasons or wrong reasons, it was the right thing to do. So I would hope and pray that many of you will open your heart, turn back, look the other direction, and we spend money, taxpayers' money, to make it easier for women to choose life for their children, make it easier for women to raise their children, to make it easier for them to lovingly give that child to another family to raise them. So I support the governor's veto. I support life, and I support all of you in my prayers to do the right thing.
Madam Speaker.
I don't know who was up.
Madam Speaker.
Yes. Go ahead.
Thank you. Yes, I stand this morning in support of the governor to sustain the governor's veto for the reason of the human life that has no choice in this situation. And again, let me repeat that. It is a human life that has no choice in the matter. And for the mothers that have decided to do that, and in many cases the data does say that they were pushed because we don't educate our children enough and our young women, and that there are options, as our former delegates had mentioned. There are many options for women to have in this situation. So, you know, for the moms, I know many of them that have been in this situation, and the emotional stress that they are left with for a lifetime is really hard for them to overcome. And I know, you know, the committee will say that, you know, the data as well says that there's more emotional stress on the women that were not able to have the abortion, but I would refute that and say that we have tons of data stating that there's women that were forced to have abortions or have abortions because they think it's the right thing to do at the time, have a lot of mental behavior and stresses that they have to live with for a lifetime. And there's a lot of sad situations. And, you know, again, I stand for human life and the choice of that baby. Thank you.
Gentleman from Baltimore City.
Thank you, Madam Speaker. Under our existing law, we do ask the right questions. we ask the right medical questions, because if a woman chooses to seek a late-term abortion, she must have the doctor's medical judgment in order for that procedure to go forth, to be carried out. And that is not with a full term, it is when it is post-viability. That's our existing law. And when we adopted that law, since we adopted that law, we've become far more aware of the inequities in healthcare in this state. And the action of overriding the veto here would expand access and treat all Maryland women the same, which is what we've done in many areas of healthcare over the last several years. I will proudly vote to override this veto. Thank you.
Madam Speaker.
Late Montgomery.
Thank you, Madam Speaker. I am very, very proud of this General Assembly that we have passed this bill, and I will proudly vote green to override the governor's veto. Not only does it say that we respect women, and that is their decision, not the government's decision, whether and when to become a parent, but it also says that we care about families. And I look at all of the things that this General Assembly has done and what we are about to do with family and medical leave. And I want to point out to the body that those states that have the most restrictive laws on abortion spend the least on maternal and fetal health care, spend the least on postnatal health care, and spend the least on supporting women and families. Yet our state spends a lot, and we care about our children, about our families, about our women, and I am very proud of our state for that. Thank you, Madam Speaker.
Thank you. Gentleman from Hartford.
Thank you, Madam Speaker. As a man in the General Assembly, I rise today to support all the women of Maryland and their right to choose. And as they make choices in their life, I want to make sure that in Maryland, we have safe, professional medical care for them. For that reason, I'll be voting green on this override. Thank you, Madam Speaker.
Gentleman from, what's it from? Hartford.
Well, thank you, Madam Speaker. I'll just be very, very brief. And you know, we've had some robust debate and a lot of motions poured out. You know, I told my story during the original debate, and a lot of people reached out to me supporting me in my story, and I'm grateful for that. But I just want to be very direct on why I oppose this, because obviously, if this veto is sustained, it doesn't limit abortion access in Maryland. But what this bill passes literally does is it will allow a 15-year-old girl to have an abortion in Maryland at 9 months, funded by the taxpayer, without the parent knowing. That's what this does. Even the most progressive pro-abortion advocates don't support this. Marylanders don't support this. Democrats don't support this. Republicans don't support this. This bill, I repeat, will allow a 15-year-old girl to have an abortion without the parents knowing about it for free. A 9-month pregnant 15-year-old girl. That's what you're voting for. That's it. That's what you're voting for. So I rise to support the governor's veto. Please, please consider what I just said. Thank you.
Gentleman from St. Mary's.
Thank you, Madam Speaker. Kind of emotional debate over this. I stand to rise to support the governor's vetoes on this. Often we have a phrase on the House floor, what problem we're trying to solve. And through this debate, we're hearing a lot about Maryland women, inequities, how before a late-term abortion, you have to get the doctor's opinion. But that's not really what the bill says, and that's not the goal of the bill. The goal of this bill is a political ramification. You know, there's a couple of Supreme Court justices that got approved by the last administration, and they're afraid that, well, let's say that other other states are changing their abortion law. You could easily rename this bill the Abortion Tourism Act of 2022, because that's the goal of it, all in the back of the Maryland taxpayer. So let's just take a look at what some of the bill does. We talked about getting a doctor's approval. Well, this expands the access to not only a doctor, which is under current law, but nurse practitioner, nurse midwife, licensed certified midwife, physician assistants. Basically expands it to anybody but the receptionist. $3.5 million of Maryland taxpayer money goes into this to perform abortions with the goal of other people coming here and satisfying the need, the service. It's not right. I long for the days when the Democratic position was safe, legal, and rare. And now instead it's anyone, anytime, and at taxpayer expense. Thank you, Madam Speaker.
Gentlelady from Montgomery.
Thank you, Madam Speaker, and thank you to my colleagues for participating in this debate. Obviously, I'm going to urge that we override the veto. There's been a lot of misinformation spread about this legislation. I just want to make sure everybody understands this bill is not radical, it is not extreme. It is actually the same tactics that we use when talking about access to health care for all other kinds of health care. Right, this is what we do with health care. We're treating abortion care like health care with this legislation. I'm very proud of us for passing this legislation and hopefully overriding this veto. I too support life. I believe in life. I believe in children. I am a mother. I believe that we need to support our children. I'm proud of what we have done as a body to support children, but I also support women's rights to make choices about their own body. And in this context, it's very important that we keep in mind that the strategies that this bill is using is ensuring that people can access the care that they need when they need it, no matter what happens with the rest of the country, no matter what happens with the Supreme Court. Many of us were overjoyed, on both sides of the aisle, overjoyed with the confirmation of Ketanji Brown Jackson. It brought us great joy to see this wonderful woman on the Supreme Court, but it does not change the balance of the Supreme Court. It does not change the fact that it has been stacked against Roe versus Wade. It does not change the fact that in less than 2 months, we are going to be hearing this Supreme Court decision, and what's going to happen is 26 states are going to limit or ban abortion. That is real, that is happening. We cannot hide from the fact that that is what is most likely going to happen within the next 2 months. We are going to have 50 years of progress on access to reproductive health care for women turned back in this country, and Maryland is not hiding from that fact. We are taking a positive action to help people. We know that this is what our voters want us to do because we had a referendum 30 years ago. The vast majority of Maryland voters supported women's right to choose, and that this bill is modernizing the choice that our voters already made. It is making sure that people have access to care, particularly people of color, particularly low-income people, particularly rural people. We know that physician-only restrictions exacerbate health inequalities, and we are trying to reduce health inequalities in the state of Maryland with this bill. So I just really urge the body to vote green on this override. We have to recognize that Maryland is one of 50 states, and in the time since we've debated this bill last on the floor, Oklahoma and Idaho and our neighbor West Virginia have all taken action to ban abortion. Maryland is taking action in the opposite direction to make sure that the residents of Maryland don't have longer wait times or more difficulty accessing the care that they have already chosen should be legal in the state of Maryland. So I thank you so much and urge a green vote.
Question for the House is, shall the bill pass with notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. The clerk will call the roll.
Madam Speaker.
Madam Speaker.
Gentleman from Frederick.
Thank you, Madam Speaker. To explain my vote, my colleague from Harford County said that thank you. He'd like to have safe, professional medical care. And you know, one of the biggest concerns with this bill is that it doesn't provide.
Excuse me, you cannot explain a vote that you have not voted on.
It's up there. Thank
Somebody
you.
else pushed it for you?
It's up there.
So yes then.
You know, and I think it's important, if we're going to allow abortions in Maryland, that we do have it and be safe. We have professional medical care. But this bill says that a doctor doesn't even have to be in the room. And you know, I'm going to vote no, because a 29-year-old school teacher from White Plains, New York, came to Maryland. She came to Maryland to get a late-term abortion. And there was a doctor in the room, but he didn't do his job. But this bill says the doctor doesn't even have to be in the room. And when he was in that room, Jennifer Morbelli died. She died because she didn't have the medical care that she needed. And this bill is a vote against women, and I encourage everybody to vote to sustain the governor's veto. Thank you.
Madam Speaker.
Madam Speaker.
Gentlelady from Baltimore County.
Thank you, Madam Speaker. I'm a red vote. I believe we should sustain this veto. Murder is not health care, people. It is simply not health care.
Gentleman from Montgomery.
Thank you, Madam Speaker. Proudly voting green to override the governor's veto of this bill. I'm a firm believer in bodily autonomy for women, for trans, for non-binary folks, and I'm also a firm believer that people should be able to make the decisions that are best for themselves in consultation with medical providers, and it is not our business to legislate to restrict that. I've heard a lot about kids, I've heard a lot about babies, and I've heard a lot about children on this floor during this debate, and I share that concern and that passion. I am not so sure if I'm compelled by those arguments, because when I look at a broken foster care system that is full of kids, by virtue of policy action or inaction, know that they're unwanted or unloved. If we truly care about kids, let's do something about our broken foster care system and not place restrictions on people's bodily autonomy. And that's precisely why I'm voting green. Thank you, Madam Speaker.
Gentlelady from Baltimore County.
Thank you, Madam Speaker. I rise to explain my red vote on this bill, and indeed, this bill is radical and it is extreme because it fails to recognize the personhood of that baby at any point. I have an Attorney General's opinion right here in my hand. You're welcome to get a copy of it. It is from March 16th of this year, written by Catherine Rowe, that says, the law does not set any limit on the ability to terminate a pregnancy. And I would ask you to look at our dear friend from Anne Arundel County, who is due to have a baby in the next 3 weeks. And this will put millions of dollars into training more abortion doctors to abort a baby at that stage of pregnancy. We failed miserably to put any limits on abortion. This is a bad bill. It does not recognize at any point the child in the womb.
Health Government Operations Chair.
Thank you, Madam Speaker. It is a great privilege today, as the chair of the committee that worked so diligently to get this bill right, and I'm so proud of the members for the work that we did. I heard 2 words on the floor today that caught my attention. One was the size of women's brains, and the other was conscience. Well, let me say to you, we all know today that women's brains are certainly capable of coming up with solutions to problems larger than their lives and about their lives. And second, we know that a conscience is a personal thing, and your conscience and your religion are not my conscience or my religion. And we are allowing women the autonomy to use their brains and their conscience to make decisions about their lives. And I thank the members of this body for their green votes today.
Madam Speaker. Madam Speaker. Explain my vote.
Gentleman from Frederick, who got up before you.
Thank you, Madam Speaker. As my colleague just said, this is a decision larger than ourselves. That's the words I just heard. This decision is about a baby, a life. And as my other colleague said, that he's supportive of bodily autonomy. Well, not so much so when you want to jab it in the arm. But here we go. When the bodily integrity of every baby that is a woman or a little boy, little girl is being ripped apart in the mother's womb, and yet we're going to pay for that with taxpayer dollars with this bill. We need to make sure this is a red vote here. Thank you.
Gentlelady from Hartford.
Madam Speaker, thank you, and thank you, ladies and gentlemen. I know that this is a very difficult and a very emotional decision for a lot of people. I can tell you that this has been painstaking for me, listening to the debate on both sides. But I rise because of the access to quality, and I do mean quality health care. I cannot accept the idea that taking a physician out of the process and allowing a nurse practitioner, a nurse midwife, and a licensed certified midwife to perform abortions is the right way to go. I don't believe that that is expanding quality health care for women.
Madam Speaker.
Gentleman from Hartford.
Just very, very briefly, I'm sorry. Just very, very briefly, I heard a comment from the gentleman from Montgomery County talking about the foster care system and being overwhelmed. That's absolutely right. There's a lot of foster kids, the system's overwhelmed. But I assure you, as a foster child, that I would much rather be here than be eliminated for the sake of the pressure of the foster care system. So I'm just going to, I just want to, so for those reasons, I support Hogan's veto. Thank you, Governor.
Gentleman from Washington County.
Thank you. Just to update also, we heard an update on what other states may or may not do, but just last week, I believe in Washington, D.C., we found at least 5 near full-term viable preborn babies cast as trash into a medical waste dumpster. And I was also reminded from the obstetricians and gynecologists who testified against this bill, pregnancy is not a disease and abortion is not health care.
Clerk will take the call. There being 90 votes in the affirmative, 46 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 937. Said bill is sent to you for your consideration.
Hearing no objection, the message is adopted. I'm on 4. Who's on? Calendar of vetoed House Bills number 4. Clerk will read the bill.
House Bill 778, Transportation Investment Program, MARC Rail Service, Maryland Regional Rail Transformation.
Gentleman from Eastern Shore.
Thank you, Madam Speaker. Could the floor leader rise for a couple questions on the bill?
Floor
Good morning.
leader.
Good morning. So on this bill, what are the projects that were that are affected by this bill? What are we doing with the bill?
Are you asking what the bill does?
Yes.
Okay, so first of all, I'd encourage you to read the bill if you have questions about the bill. I'm going to give you a brief summary, but we all have floor systems, and these vetoes came out last night. But I'm going to explain it to you because I love talking about railroads. This bill is designed to advance some of the existing projects that the Maryland Transit Administration has been pursuing on the MARC commuter rail system. Some of those projects include run-through service to Pennsylvania, or excuse me, to Delaware, run-through service to Virginia and Washington, D.C., as well as expanding our service out to Western Maryland.
So in this process, MTA is taking steps for these projects already in that they need agreements from host railroads before they can move forward. Is this bill contemplating that, the need for that to happen?
So yes, these are all existing projects. They're all things that are already in some plans from the Maryland Transit Administration and the Maryland Department of Transportation. However, they haven't moved far enough or fast enough, and we're being basically lapped by Virginia when it comes to commuter rail programs, and this is designed to spur them along. You are correct that the Brunswick line, the Canman line, and the Penn line, the lines themselves are not owned by the state of Maryland. They're either owned by CSX or Amtrak, and so things we do on those lines do require cooperation with them. That actually is anticipated by the bill, and the statement in the veto override letter, which is new, it was not in MDOT's informational statement, that these plans would not be used because of the need for that coordination, is, I'll say, misinformed. I'll put it that way.
Okay, so how can you say that the bill is contemplating the negotiation and the agreement that has to occur, because obviously the bill is mandating certain things that these other partners may say no to?
No, that doesn't do that at all. What the bill does is takes existing plans. So, for example, the run-through service to DC, right? That is something this body passed, I think, 3 years ago. So maybe at the time then was to say, well, they're never going to allow us to do that. But that time has passed. We have already passed that bill. That is now the policy of the state of Maryland, and the MTA should already be pursuing that. So we're not saying you have to begin running run-through service tomorrow, or you have to build a new line along the Penn line tomorrow. We're saying you need to move forward in that direction, including engaging with the host railroads in those necessary negotiations, doing the rail simulation models that are called for in the bill, and so on. It's absolutely correct that we need the participation of those other entities, but we can't just sit around and wait for them to do it for us. The MARC system is a state commuter rail system. CSX, Amtrak, they're not going to do this for us.
So to be sure about what you just said there is that if we move ahead and MTA is saying it's going to cost $13.9 million to put this plan together, do you think, do you think we're putting the cart before the horse? Because what happens if you put this plan together because we're in a rush to do it and we want to force this through, and then you come to the realization that whatever it is you and I may want as a legislature all of a sudden is not going to work, or the other partners are not going to play ball?
Yeah, that's why we're not that prescriptive, delegate, right? We don't tell them exactly how they have to do things. Obviously, it requires them to do the planning. We're not the technical experts here in the General Assembly. They do the participation of other parties. But these are ideas and concepts that have been in the MTA's plan sometimes for decades, and we need to spur them along. And yes, part of that is working with these other entities, but these other entities also have responsibility to us. There's laws they have to follow to allow us access to the lines for commuter rail.
Of course, I'd argue that the bill is quite prescriptive because it's going to deal with other projects that are going to be jumped because of this project. So the question is, if we pass the bill, what happens to projects that are already in the pipeline?
Yeah, so I also read the veto override letter. First of all, we're talking about $13.9 million. Okay, the other day, the minority leader yada-yada $150 million out of the Transportation Trust Fund. But I'm glad to hear we're all very concerned about the integrity of the Transportation Trust Fund. $13.9 million, it's a lot of money to you, it's a lot of money to me. It's frankly not that significant in the scope of the, I think, $8.5 billion CTP. They have a lot of room to move money around. This bill does not mandate that they begin constructing the third track that I want on the Brunswick line through Montgomery County. We pulled that out of the bill because it was too expensive for the reasons you're citing. $13.9 million, it's an important investment, but it's nothing the Maryland Department of Transportation, in all their wisdom, can't figure out how to move money around and handle.
Okay, well, it's interesting that you're saying that you care about the Transportation Trust Fund, as we were listening to the majority leader the other day talk about just such a thing as we were doing the gas tax, and yet here we are with a bill that's taking money out.
Gentlemen, are you on
Right.
the bill? Are you doing
Almost.
like second reading?
Well, of course I am, because I think that the governor is bringing issues forward, and I'm asking the legislature to respond in kind. It's a bill that I think creates some difficulties. Ultimately, Madam Speaker, what happens when we take projects like this, where we're saying that we're going to do this before we get agreements from other parties that have to be party to the agreement, at the same time that we're pulling money away from the Transportation Trust Fund? We're doing it in a way that says there are safety projects that may be removed and or moved in the line of our queue of work that's being done. We just had a bill that I stood on about 20 or 30 days ago that wanted the exact opposite to happen to what this bill is. They wanted the safety projects to stay in line, yet here we are saying, okay, well, wait a minute, we're okay with maybe taking a back seat on some important safety projects so we can have this political conversation about rail, which, you know, ridership, maybe it...
You're having a political conversation?
I'm debating the bill now according to your request. So I'm right with you.
No, I didn't ask you to debate the bill. I just want to know whether or not, why you're for or against the, what was before you.
Okay, well, Madam Speaker, I'm supporting the governor's veto because
That's what I wanna hear.
because and the debate back and forth with the floor leader goes to, we have a very narrow purpose here. We're taking a very broad department and we're saying you're going to spend money in a certain way. That comes at the expense of certain things. And so having the conversation with the floor leader is a couple points. Number one, we're negotiating on behalf of MDOT, and I'm saying that if you do that and you can't get buy-in from other partners that you need to make these rail projects work, you may end up spending $13.9 million putting a plan in place that you simply cannot use. And being prescriptive as a legislature in this particular instance also comes at the expense of safety projects that $13.9 million might be used for, that the department all of a sudden is saying because the legislature is mandating it, we have to do that, and that's a problem. The last comment, Madam Speaker, and why I support the governor's veto is that this does have an impact on the Transportation Trust Fund. And I'm worried, Transportation Trust Fund is pledged to pay debt service on bonds and then pays all operating expenses for all of MDOT. Since there are no unspent funds in the Transportation Trust Fund to address any new mandates or spending, this bill is going to drastically impact MDOT's bonding authority, putting MDOT's credit at risk. So, Madam Speaker, to the point that you're bringing, do I oppose the bill and do I support the governor's veto? I do, because yes, I did read the governor's veto letter, and yes, I think that it's important policy making that we don't take away from MDOT what they can and should do for themselves. So for those reasons, and I regret to not have further discussion with my friend from Montgomery County on rail, I think this is a pretty easy bill to support the governor's veto on.
The question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Madam Speaker.
Yes,
To explain my vote,
Explain
Madam
your
Speaker.
vote.
Thank you, Madam Speaker. I just wanted to thank this body. A few weeks ago, we had an overwhelmingly bipartisan vote in support of this legislation. It's a statewide commuter rail package. It's important for the Upper Eastern Shore. It's important for Western Maryland. It's important for Baltimore. It's important for the DC suburbs and lots of places in between. It's a great package. I'll even thank the Senate. They had an even more overwhelming bipartisan vote in support of this bill, and I'm looking forward to this moving forward. Thank you, Madam Speaker.
Okay. Clerk will take the call. There being 103 votes in the affirmative, HB 778 and 30 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 778. Said bill is sent to you for your consideration.
Hearing no objections, the message is adopted. I think we have two members want to acknowledge guests. Gentlelady from Montgomery County.
Thank you, Madam Speaker. Walking back in, because I needed to run outside to grab my own hug, I'd like to, I know a lot of people have seen pictures of my daughter over the last few years, but she hasn't been here since opening session 2 years ago. So there's AJ right there in Nancy's arms. And thank you, and of course, my wife Nancy and our friend Kristen Rowe. Thank you, Madam Speaker.
Gentleman from Baltimore City.
Thank you so much, Madam Speaker. So I have a similar story that everyone sees my daughter on the internet, and she's actually here today with the rest of my family. So I have my daughter, Amara, my beautiful wife, Normandy, and my parents-in-law came here all the way from Georgia. So if everyone would greet them with a great hello. Thank you, Madam Speaker.
Madam Speaker.
Gentlelady from Carroll.
Thank you, Madam Speaker. I was going to bring my family down today, but I have 5 little ones under the age of 3, so they're coming tomorrow. But my husband is here for the weekend. Mark, he's my campaign manager, and he's so happy to not have to be putting up signs this year. Thank you.
Gentlelady from Prince George.
Thank you, Madam Speaker. And in a few minutes,
flying through those doors up there, maybe my husband and my son, they were here and just stepped out. But they have, here they'll be coming in. But anyway, when you see him come in, he's 6 foot tall. He was 2 years old when I started this journey, and we all thank our family for helping support us. We wouldn't be here without him. So eventually he'll come through those doors, my husband and my son. Thank you. There they are.
Okay. Calendar of vetoed House bills number 3. Clerk will read the bill.
House Bill 609, Local Health Officers Removal Process.
Madam Speaker.
What it is. Young lady from Carroll.
Thank you, Madam Speaker. We had a long discussion about this bill when we had it on the floor earlier, but I just hope you all had some chance to speak with your local elected officials in your counties. So I rise here today to support the governor's veto and ask the body as well to sustain the governor's veto by voting red. Let's just talk about current law. This bill has to do with local health officers and how they get the ability to be hired or fired. So currently, a local health officer for a county must be nominated by the county and appointed by the Secretary of Health. If the Secretary of Health finds that a health officer nominee meets the specified qualification, the nominee must be appointed. So it's up to your local jurisdiction to find a suitable candidate, and as long as they meet the criteria, that local candidate gets appointed. And there's qualifications that are in the law. To remove a current law to remove a health officer, they serve at the pleasure of the appropriate county's governing body and the secretary. The health officer may be removed from the office with concurrence of the governing body of the appropriate county and the secretary. All information concerning the removal of a health officer is confidential, and as such, anything related to the removal of a health officer involving the county's governing body, includes the secretary, must be closed, must be kept confidential. So what does this bill do? Well, first of all, I want to mention that during our health officers are very important in all the work that our health departments do, and they are a critical part of the state's public health system. And they must be commended for their selfless and tireless leadership, especially during the pandemic. But this bill that we have in front of us creates a dangerous precedent and significantly undermines the voters and the Maryland Constitution, which entrusts the executive branch with making appointments critical to government roles. This bill will make a local health officer unique and separate them from all other state appointees by establishing specific and arbitrary criteria which must be considered prior to their removal. Currently, all appointees, think about all of local government, many of you served in local government before you came here, but currently all appointees, including local health officers, serve at the pleasure of the appointing authority. This bill will establish personnel standards for local health officers that are significantly different from similar positions in state and local government, your own local government. The Maryland Association of Counties opposes this bill, and that's all your local elected officials in all of the counties. Serving at the pleasure of both governmental levels, the county governing body and the state secretary already offers state health officers a layer of protection not afforded to other appointees, but suitable, given their hybrid station across both levels of government. This bill is an overwhelming administrative burden and politically undemocratic. Maryland's local health officers have helped prevent COVID-19, the pandemic, from taking countless lives. We all recognize the tough job that they've had. Their work has been laudable and deserves the highest praise. However, a health officer's work is only possible by having the buy-in of county leadership and the public, our constituents. And I'm reading from Mako's letter. In a situation which a health officer was to disregard local, state, and federal guidance and breach the public's trust, this bill would potentially protect them from termination or prolong their termination process, preventing the installation of a successor. No other appointee position reporting directly to elected county leadership is afforded this level of protection. Moreover, this bill removes the discretion and autonomy available to newly elected county leadership. We have new county leadership coming in next year in all of our counties. So the county leadership will not be able to select the heads of their local health departments as they will for all the other departments. For these reasons, this bill is, I guess, intended in good intentions, but it creates substantial protections for bad actors and dilutes the ability of the voters to influence policy. And during our testimony, of course the health officer is opposed to this. We've had a tough time last year with our health officers. It's been an interesting year in unprecedented times, trying to figure out what the science is and what to do in each county. But I believe that working together with your local officials, with your county elected body, is the way to strengthen the relationship and the cooperation between the health officers and the elected officials and local leaders. In the testimony opposing this with the Maryland Association of County Health Officers, obviously, you know, it was some tough times last year, but they kept talking about this procedure they supported the bill, obviously. This procedure would lessen the potential for political pressure to influence decisions that directly impact health and safety of Maryland residents. I would urge to just mention that everything we do, we call political, but this is about having a discussion and debate with accountability, and your local elected officials are the people that are accountable to the people. They're the people that were voted into office. These health officers are not elected. So unless we want elected health officers, they need to account to someone, and to me that's the elected officials that we the voters put into office to put the right people in place. So I would suggest that we look at the precedent that we're setting here, because this is just one and what will be next, and this really does weaken the elected officials and the people that put them in office from having any say. And your local health officers have an unprecedented say over our property, our lives. Last year they could quarantine people, they could tell you couldn't leave your home for 2 weeks. That's a pretty unprecedented power. Actually more so, I think, than a sheriff or some of our law enforcement. And law enforcement even has accountability. They're either elected, your sheriffs, or they're appointed by your governing body, and you can let them go if you don't like what they're doing. They serve at the pleasure. So keep that in mind. This is an unprecedented thing that we're doing here because of a situation that happened last year with a couple of health officers, one in particular that the county was never able to defend the decision of why they were let go. We're not allowed to do that because of confidentiality. And with very little background on what was going on, we put this bill in place, and I think it is premature and it's precedent setting, and I urge the body to sustain the governor's wise veto. Thank you.
Madam Speaker.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. Colleagues, I stand and rise in support of the governor's veto, and I do agree that the HB 609 sets a very dangerous precedent. And furthermore, it undermines the voters and the wisdom of the Maryland Constitution that entrusts our leaders and our executives to make appointments that serve at the pleasure of that executive. An executive is nothing more than somebody that manages or administers an organization. When we vote for our leaders, whether it be a president or an county executive or a governor, we're entrusting them to build a team that can operate together and cohesively to bring about effective governance. Let's not look any further than this body. We elect a Speaker of the House. We entrust our Speaker to appoint leaders. She does it often. She does it for chairman. She's putting her team in place, and they serve. And I'm sure every one of them will tell you, they serve at the pleasure of the Speaker because she can remove them. That's the point of an executive. The Speaker gets to build her team. Hence why my good friend from Calvert County, probably not a chairman, but that's why she's the leader of this body. Because everybody in here voted to put her into that leadership team. Now that's a hypothetical when it comes to my friend from Calvert County who's strutting back to his seat. But let me tell you what really happened in Anne Arundel County. In early January, the county executive declared a 7-day state of emergency and put a mask mandate back into place, well within his legal rights. He did that unilaterally, 7 days. But in the Anne Arundel County Charter, it says that you must get the county health board's approval in order to extend it more than 7 days. So he went to the county health board, which happens to be our county council. The Anne Arundel County Charter says you must have at least a 5-2 vote. They had a 10-hour hearing, and it got denied. That vote went down. The county executive and the health officer then decided, well, we're going to put this mandate into place without the county board's approval, which is clearly stated in Health Article 18-208, but then he cited the same health article. That health article says if the health officer of any county or Baltimore City believes there's an infectious disease that could harm the public, that health officer must inform the Maryland Secretary of Health and the county board to get approval. He did not get approval from the county board. I asked on January 8th, the Maryland Department of Health, if you authorized this mask mandate, yes or no. And as I often share the same frustration with my chairman with the Maryland Department of Health, I got an answer of, we take no position. Not a yes, not a no, we take no position. So suddenly, I have a health officer that is mandating things on the Anne Arundel County citizens that was not authorized by the health board, was not authorized by the state of Maryland. This is what we call authoritarianism, and it's dangerous. I'm not sure it's always going to happen, but what if the next county executive has a differing opinion? We all know, now we're starting to hear all the time, science changes. Well, not everybody's always going to agree. We have to entrust the leaders that we elect and the executives that we elect to put a team in place that is going to operate in a cohesive manner that is best for the public. When we have two people or two positions in opposition, it creates chaos within a government body. This is a very dangerous precedent. The next county executive may have wanted a mask mandate, and the health officer say, you know what? I don't care what you want. I can do what I want. You can't fire me unless you go through this arduous and arbitrary process of trying to have me removed, which can take weeks to months. Meanwhile, the public's health could be at stake and in danger. For all of those reasons, Madam Speaker, I stand in support of this veto.
Recognizing the Vice Chair of the committee.
Thank you, Madam Speaker. That this legislation is necessary is an unfortunate reflection of the undue political influence we have seen in our public health policy. Since the COVID-19 pandemic began, public health officials have increasingly become political targets. They have experienced retaliation from elected officials, as well as vital harassment and threats of violence to their lives from the public. The governor's veto justification is factually erroneous by stating that the bill established, quote, specific and arbitrary criteria which must be considered prior to the health officer removal, ignores the amendment that we placed on this bill. The bill eliminates, the amendment eliminates the specific categories as ground for termination. We got rid of that. In addition, the statement, the House Bill 609 creates precedent, and we have heard that on this body today and in the governor's letter, and will make local health officers unique and separate ignores the fact that this legislation is based on the due process that has been granted to local school superintendent for years. What you have in front of you doesn't change the process, basically adds due process so that they can know why they're being let go. Simply put, due process, fairness. Now more than ever, it is imperative that we guide our policy by science and ensure that our well-qualified health officers have some level of insulation from political divides. It can very well be a matter of life and death. Please vote green.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Would anyone like to change their vote? If not, the clerk will take the call. There being 97 votes in the affirmative, 41 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 609. Said bill is sent to you for your consideration.
Hearing no objection, the message is adopted. Calendar of vetoed House Bills number 6. The clerk will read the bill.
House Bill 1021, Public Safety, Licensed Firearms Dealers, Security Requirements.
Question for the House is, shall the bill pass notwithstanding objections of the Chief Executive? Gentleman from Frederick.
Thank you, Madam Speaker. I actually rise to support the governor's veto, and I ask my colleagues to sustain the veto, and I do so for the following reasons. There is no question that in our state, our great state, that violent crime has been consistent, persistent, and in some cases on the rise. And the majority of those crimes deal with firearms offenses. And if you ask local officials in various jurisdictions, they will tell you that a lot of those offenses are done with stolen weapons. It's true. And as I understand it, this legislation before us is disguised as a bill to address that issue. Stolen weapons, committing violent crimes in our state. So I looked at the numbers. So last year, according to the fiscal note, there were about 150 stolen guns from FFL dealers. Now that's out of 210,000 guns that were sold from those same FFL dealers. Some may even point to a couple instances that occurred, one in Howard County, one in Baltimore County, when an individual stole a vehicle and drove it into a gun shop in a brazen attempt to steal guns. But what this doesn't do, and let me back up for a second. The bill attempts to address these issues by requiring these FFL dealers to have video surveillance, bars on their buildings, security screens, commercial-grade metal doors, grates, and other physical barriers, and they have to install these within 6 months. And I'm assuming it's to address these brazen heists of people driving into gun shops. But the irony here is that it's a felony to steal a car to drive into a gun shop, but it's not a felony to steal a gun. Furthermore, most of these FFLs, a lot of these FFL dealers are home-based. So we're now going to require a home-based FFL dealer who lives in a neighborhood to install video surveillance, bars, security screen, commercial-grade metal doors, grates, physical barriers on his house. This sounds like a bill that is attempting to punish law-abiding gun sellers or to thwart law-abiding gun ownership. That's what this really is. This isn't a bill to address stolen guns that commit violent offenses in our state, Because if we actually wanted to do that, we wouldn't have stripped theft of a gun as a felony out of a bill that we'll probably hear either later today or on Monday. The Senate passed a bill that would have made theft of a gun a felony. And in the House, we stripped it out. So I'm going to vote against this. I'm going to support the governor's veto. I'm going to ask my colleagues to support and sustain the veto because I don't think we should be penalizing law-abiding gun ownership, law-abiding gun sellers, instead of going after the real issue, which is theft of a gun. We need to penalize the people stealing guns and not the people that are legally selling them. Thank you, Madam Speaker.
Chairman of the committee.
Thank you, Madam Speaker. I'm going to ask the body to override the governor's veto today. The committee, the speaker's staff worked extensively with the industry on this legislation and made significant changes that they requested in the legislation. The member from Frederick, I don't think he meant to be, I think he wants you to believe that all of those things are required. We actually just require one of those things. One of those things: bars, security screens, commercial grade metal doors, grates, or other physical barriers approved by the secretary. The governor in his letter makes you think that we were requiring all of those things. All we're saying is, if you're selling guns in the state of Maryland, we would like you to take these steps to make sure that security of your business is paramount, that you've got a camera. What's wrong with that? That's the basic level of what we should expect when somebody is selling a firearm. And that's where the level of debate, I believe, that we've kind of sank to on all of these issues. We're not going to deal with the practical, with the things that actually matter, making sure that guns are secure when they're being sold. We're not going to make sure of that. We're going to change it from a misdemeanor to a felony because that's going to change everything. It's not going to change everything. It's not. We have to do the things to track illegal firearms. This is one of those things that we can do to prevent them from being stolen and going into the flow of commerce. That's why I'll be voting to override the governor's veto.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. I rise in support of this veto because I believe that everyone, and I also believe that everyone in this chamber believe in securing firearms, believe in making sure that those firearms are secure, not being used for, are being stolen. But unfortunately, I don't think this bill went beyond reasonable. Some of these measures that the chairman mentioned, yes, they're one of the four, but the four are still extremely expensive and sometimes in some areas extremely undoable. Every FFL dealer understands and recognizes the need for reasonable safety measures when dealing with firearms. This bill had little to no opportunity for public to weigh in, at least in the Senate side. Also, this bill is a one-size-fits-all legislation that will negatively impact businesses of all sizes, even the little guys that work out of their homes. According to the state police, there's 100 dealers that work out of their homes, and that includes gunsmiths. They cannot put physical barriers. They cannot afford also 24-hour security inside and outside their homes that has to be continuously monitored. Those gunsmith dealers, they take pieces apart, and sometimes they work on multiple firearms at the same time. And if they paint them, they need to dry. Under this bill, that means they have to put it inside the safe during the hours that they're not working. What about the manufacturers, the Berettas of the world that they already have taken security measures? How does this apply to them? This bill doesn't really say. I mean, Beretta has a secured perimeter. They have 24/7 security guard that's monitoring. Under this bill, they will not be in compliance. It also only gives 6 months for all those dealers to comply with those regulations. You know, I've been here for 8 years, and during my time on HGO, we have always tried not to have a one-size-fits-all approach when working with legislation, and brought all stakeholders to the table, and we make sure that their concerns were addressed. This wasn't done here, with all due respect, and for that reason, I urge the body to sustain the governor's veto. Thank you, Madam Speaker.
Gentleman from Garrett.
Thank you, Madam Speaker. The chairman of Judiciary just mentioned, or just made a statement. He said, what is wrong with trying to prevent people from stealing firearms? So why are we taking extreme measures to hurt businesses that are legally operating in the state of Maryland? In many cases, especially in rural areas where I live, those businesses are next to or at the homes where they live. So we have those small dealers that are licensed to sell firearms. They're going to have to put bars, going to have to put iron gates, they're going to have to bar up their windows and do things to protect against somebody from stealing their firearms. But what we've tried time and time again to get this body to pass legislation to make it a felony for stealing firearms. But now instead of making it a felony to steal a firearm and going after those.
Gentlemen,
yes.
keep your remarks on the actual bill.
That is, Madam Chair. Madam Speaker, I'm sorry, Madam Speaker. Got emotional here. So I'm speaking on the bill. The bill, what it does is prevents businesses, it affects them businesses, impacts them businesses, and makes it harder for people that are in business that have licenses to sell firearms to be able to continue to stay in business. And it goes really to the people that does not address the people that are stealing firearms. And so we have tried to keep people that have been attempting to steal firearms or would steal arms to, instead of making it harder for people to steal firearms that want to steal firearms, or making it harder for businesses to exist in Maryland. So for those reasons, Madam Speaker, I will vote to sustain the governor's veto. Thank you.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? Green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone
Madam
recorded
Speaker.
their vote? Gentleman to explain his vote?
Yes, Madam Speaker. Just quickly, you know, the requirements, it was just mentioned, I'm going to explain my red vote. I support the governor's veto. I heard some arguments that this legislation is simple. It's not a big deal. There are many FFLs that operate out of their home. I can't believe that they were a part of the process. The requirements in here are unreasonable. And this legislation is just, it's such a disappointment at a time when firearm-related crime is a priority, that we're going to move forward with these requirements, thinking that we're making our community safer, and meanwhile knowing the reality that it's going to do nothing to stop criminals and the behavior of what they're doing. It's just a big disappointment, and I'm proud to be supporting the governor's veto. Thank you.
Clerk will take the call. There being 97 votes in the affirmative, 40 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of House Bill 1021. Said bill is sent to you for your consideration.
Hearing no objection, the message is adopted.
Now I got it.
Senate Bill 275, message from the Senate. The clerk will read the message.
Ladies and gentlemen of the House of Delegates, the Senate today, notwithstanding the objections of the governor, voted to override the veto on Senate Bill 275. Said bill is sent to you for your consideration.
Hearing no objection, the message is ordered journalized. Clerk will read the bill.
Senate Bill 275, Labor and Employment, Family and Medical Leave Insurance Program Establishment.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? Gentleman from Eastern Shore.
Thank you, Madam Speaker. So I'm glad we heard this earlier, second chance, but with this one here, I really am happy to see a second chance because I think there's still so many questions. Here we're putting together something that we don't have all the answers, things that are still yet to be decided. We really did something great with the gas tax. I think we all applaud ourselves, heard good feedback in the community. That gas tax saved probably $7 to $10 a week for the average person. But yet, this is something that could cost $15 a week. So we're kind of undoing all the good we've done. We can, if we sustain this veto, we could think of ourselves as like gas tax exemption for perpetuity. I mean, I know that's a far exaggeration, but I'm really being serious as to in these times, the financial demands we're going to be putting on people with this. When I stood on the floor before, I talked about the seasonal folks. And the more time that's lapsed, the more feedback I've gotten. You know, we have to be serious with ourselves. I don't think that was the true intent. There's also questions. I've read through the bill several times, even the amended version. If there's an employer with 20 employees in the summer and only 5 for 9 months out of the year, in the off season 8 months, where do they stand? They have five employees at one time, 20 in another. There's just so many questions. Folks, I really urge us to take advantage of this opportunity to give us a chance to do this right, to do the study, and put this together when we have answers to all the questions. Madam Speaker, I hope that we can support the governor on this one and sustain the veto. Thank you.
Young lady from Carroll.
Thank you, Madam Speaker. I rise in support of this veto as well. This bill, this policy is not ready to be implemented. The estimated fiscal impact is $1.6 billion. However, it was admitted and discussed on this floor that we do not know exactly what the cost will be. This bill is a payroll tax, a new tax on businesses as small as just 15 employees, the very smallest of our businesses. We don't know what the payroll tax will be to the employer or the employee, because we are going to figure this out after we pass this bill. As I stated before, passing a bill with such a huge fiscal impact with so many unknown answers is like building an airplane while careening down the runway. Let us sustain this veto. Let's do the actuarial analysis. Let's listen to all of the stakeholders, especially our smallest businesses. Let's not rush this with such potential harm to our small business community. I urge you support the veto. Thank you, Madam Speaker.
Gentleman from Talbot.
Thank you, Madam Speaker. And I've said it before, and I'll say it again, this bill is a mistake. This bill, it's the wrong idea at the wrong time. It is it's at least $1 billion. It's a payroll tax on our employees, private and public. It is a payroll tax at a time when we are at the highest rate of inflation in over 40 years. There will be a recession. It's coming. Every major financial economist in the country is predicting it. It's a question of whether it's 1 year or 2 years away. We're going to put this on the Maryland working families. It's hard to believe we would do that. It's just out of touch with what's going on. But take another step, okay? Let's look at what this bill does. It creates a new agency or a new division in the Department of Labor. They're going to hire 400 employees, right? And they're going to stand this up, in less than 5 months, or give them 5 months to a year and a half. Well, if you remember, in 2016, we did something. It's called the Maryland State Small Business Retirement Savings Board in the same department. 2016. The Department of Labor has put $1.3 million into this program, okay? It's for workers. 6 years later, we're talking $1 million program, okay? The bill contemplates a $1 billion program, okay? 6 years ago, a $1 million program has failed to launch. So we're going to put a payroll tax on Maryland working families with the high hope that somehow we're going to figure out how to put together a $1 billion state-run insurance program when we can't even manage a $1 million retirement program. The governor's veto is well placed, and I'd encourage everyone to support it. Thank you.
The chair of the Economic Matters Committee.
Thank you, Madam Speaker. I urge us to vote to override our governor's veto. I read his letter. I listened to my colleagues on the floor, and it's just never a good time, is it? It's never a good time. The economy's never good enough. There's never going to be a time to do this. I love when people say, oh, you know, I support the policy, but not this year. But if not now, when? Because that's the problem. Everyone says they want to protect workers, but then we have an opportunity to do it, and there are flaws in the bill. There's something they don't like. We've been discussing this since the early 20th century. Paid family leave. We're one of the few remaining countries in the world that doesn't provide this for our workers. It throws me off. I hear about, well, you know, we're doing all this, and we're not collecting a dime until after next session, just for the reasons that were brought up. The problems, because I know that this is complex, but it's important. We're taking our time. We're doing the studies, not only from Department of Labor, to ensure Department of Labor can even do this. We'll have the information. We are the arbiters. We're gathering the information, but we're not going to do is say, well, no, let's wait another year. Let's wait another year. No, because it's not right. I mean, the weather the weather's not right. There's always going to be a reason to not do this. Then stop telling me you care about workers. Stop saying that you want to protect people's wages if they get sick. Just say you don't like the policy. I'm fine with that. But I do like the policy, and we have to get this started. At some point, we have to point this ship in the right direction and start the engines. Otherwise, we will never get anywhere. And now's the time. We have left plenty of things open. Oh, we don't know what the split is. Correct. Because we didn't want to rush and do that in this economy until we got the studies and the actuarials back. We wanted to make sure the Department of Labor was able to handle this. Or do we have to farm this out to a third party? I hear the word, we're climbing Mount Everest. 10 other states have already done this. This isn't an impossibility. This has been thought through. And here's the thing. The answers that we don't have, we're looking for. We're not going to guess, and we're not going to rush. This doesn't start in earnest till October of next year. We will have come back and have made some decisions on how we're going to do it. I don't mind you saying you don't want to protect workers. I don't mind you saying you don't want to protect their wages when their families are sick. But just say that. Because at the end of the day, it's never going to be good timing. We just had a global pandemic. And we hear, and I read the governor's letter about the 40 years high inflation. You know, the pandemic, families suffered. They lost family members. And if you remember, they also had to lose family members that they couldn't come around. People started gaining more value, remembering why they were here, and it wasn't to go to work every day. So they started dropping out of the workforce in droves because they're saying, you know what, the $5,000 after gas and after car payment, I'll just stay home and we'll have a single worker in the family. They started choosing their families, and I want them to not have to make that decision and split it up. We're going to incentivize these individuals to come back to work. This departing workforce, we're going to clear that up. We're going to provide a benefits package for somebody that works a minimum wage job. What's so villainous about that? They're investing in themselves. We're asking them to do that. The pandemic should have shown us one thing. People get sick. People die. How are you going to spend your life, working or caring for your family? This allows them to do both and still get paid. There are things that we have not thought out. There are things that we're still discovering, and that's why we have the study. That's why we didn't implement it till next year. So please just tell me you don't like the policy. I'm fine with that, because there's never going to be a time. But I'll tell you the time is now. We're going to bring these workers back. We're going to have them motivated to come back, and we're going to protect them. I want somebody who has a child to spend that full 12 weeks and not have to say, like my former Laura, I got to come back early. I just had a baby, but 6 weeks is all I can afford. I don't want that to happen again. And she worked hard on this bill because she wanted to make sure other individuals did not have to make the choice that she had to make. I want to make sure that if your grandmother is dying, that you can spend those moments with her, not at work thinking about her. And you all know how that goes, man. Regret is forever. I want to provide this opportunity for those individuals, and I want to provide a plan, and I want to get it started now. There's no reason to delay. There's no reason to wait. Now is the time. Please override the governor's veto. Thank you.
Madam Speaker.
Madam Speaker.
Gentleman from St. Mary's.
Thank you, Madam Speaker. I stand to rise in support of the governor's veto on this because I don't like the policy. I don't. This notion that we're going to bring workers back to the workforce, first of all, they're not workers, they're employees. We don't live in Cuba, they're employees. And we're going to bring them back to the workforce by increasing taxes on them. Does anyone think that's a great idea? I mean, I've never seen people come back to the workforce. We're going to raise your taxes. This is a $1.5 billion tax increase. How much does the employees pay? We don't know. We don't know. We'll figure that out later. We're going to collect it later. It's always later. So what's driving this? Well, there's an election coming up, and this bill polls incredibly well. And it polls well because employees don't know that they're going to pay for this.
Madam Speaker?
Yes.
Point
Yes.
of order. I think the gentleman has forgotten that we don't impugn motive on the floor.
We're not impugning motives, Madam Speaker. I'm simply suggesting that we're passing the bill now, collecting the money later after the election. That's not impugning motives. That's a statement of fact. That's what the bill says. So we do have an election coming up. And there's a reason why we're passing it now. I believe that the reason why we're passing it now is because of the election. $1.5 billion tax increase.
Wouldn't that be motive? You just gave her what she said you're accused of, and you just did it.
How's that impugning anyone's motives? That's a statement of fact. The election is coming up. We're passing the bill today.
You can't.
I mean, how's that impugning a motive?
May I explain,
Madam Speaker, I would finish, and we get through this
Thank you,
very
Madam
closely.
Speaker. By connecting an election to a vote, instead of talking about the policy that we're voting on, is impugning motive as opposed to addressing the content that those of us who voted green on believe in.
Okay, I'll address that. So we're voting green to override the veto on a bill that'll be implemented after next year. We'll collect money for 18 months before anyone receives a benefit. And we know there's going to be problems with this. Look, the policy, I don't like it, but I do think it was well-intentioned. I understand, and it will help some people. There's no doubt in my mind that it will help some people. There will also be a whole lot of people that take advantage of it. When we're starting talking about employees and how they find jobs, you know what the ultimate safety net is? The market. Because when you can't find a job, you know what? You can go to another job. And when we're sitting there strangling businesses time and time again, taking $1.5 billion, not just from the business owners, but from the employees, that is a big problem. I stand to rise And I urge a green vote or a red vote, abstain to veto on this. Thank you, Madam Speaker.
Gentleman from Montgomery.
Thank you so much, Madam Speaker. So obviously, I'm going to urge that we override this veto. The market has not solved this problem. It has continued to not solve this problem for many, many years. I introduced this bill for the first time, I think 7 years ago, but have been working on it for 12 years. We have been studying this in different states for more than 20 years since California first did this. The U.S. Department of Labor helped Maryland and particularly Montgomery County by doing a study looking at how this has worked in other states. That's why we've gone from 3 states to 10 states during the time that the state of Maryland has been considering implementing a program like this. It is not out of touch, as it has been referred to. It is, in fact, very in touch with what the people of Maryland have been going through, particularly in the last couple of years during the pandemic. This is a social safety net program, and if we have learned anything during the pandemic, it is that people depend on social safety nets. This is a program that is going to be extremely popular. That's why it polls well. It is a program that people on both sides of the aisle know that we need. It is going to protect people in the workforce, and particularly, and I tell you this as someone who runs a small business. I have run small businesses throughout my career. I have also worked for small businesses throughout my career. It is designed especially for those vulnerable employees who work for small businesses. When I was pregnant with my first child, it was the hardest conversation I ever had to go to my boss who had 4 employees and say, I know what a burden this is for you, but I'm having a baby. How are we going to deal with it? There was no structure in place. There was no system in place for my boss, the owner of that business, to figure out how to help me, how to do the right thing for me, while she was also doing the right thing to keep the business afloat. A program like this allows those smaller businesses to compete with the big guys, right? This program is for those folks who work for the small and the medium-sized businesses, those businesses that cannot afford to provide 12 weeks full paid time off. A program like this is going to create a social safety net so that those businesses and those employees don't have to live in a world where, like we have now, 25% of women go back to work less than 2 weeks after giving birth. It is wrong, and overriding this veto is the right thing to do. I urge a green vote on the override.
Madam Speaker.
Madam
Speaker. Madam Speaker.
Minority Leader.
Thank you, Madam Speaker. I just want to say this. I'm not going to get too deep into all the policy debate, but I do want to say this. Do not say that we do not care about workers. Do not. I have 4 grandparents. One of them was a coal miner who never went past 7th grade. He's my grandfather. I knew him. Never went past 7th grade. I had another one was a truck driver. Graduated high school, immediately went and served in the United States Army, landed at Normandy on D-Day +5. First time he'd ever been out of Garrett County other than to go away to be trained in the Army. I had 2 grandmothers, one of whom never graduated high school, had 13 children, including my mother. 2 of whom are lawyers, 3 of whom became very successful businessmen, 1 of whom became the elected clerk of the Circuit Court of Allegheny County for 32 years. My other grandmother I was incredibly close with, was one of the smartest people I ever met. Born of an alcoholic great-grandfather. My great-grandfather abused my great-grandmother. They ran away. My great-grandmother, who came here from Scotland, had no education, was one of the first people in Allegheny County to ever own a business as a woman. She started a restaurant on her own so she could support her kids when she ran away at the age of about 35 years old from her alcoholic, abusive stepfather. My grandmother was incredibly intelligent. She would have been as intelligent as anyone in this room. Couldn't go anywhere, couldn't do anything. They had no money, they had no opportunity. They worked. My mother was a single mother. My parents got divorced when I was 3, 4 years old. Single mother, put herself through college, put herself through law school. And my story is not unique, just like yours are not unique. And they're not defined by who's a Republican and who's a Democrat and elections. They are not. Do not say that we don't care about these people. That is impugning our motives. We do. We disagree with you about how to best implement these things in our capitalistic society. We disagree with you about the effects that they will have on our economy. We disagree with you that when we implement policies that our neighboring states do not, that it won't have a deleterious effect on what we all want, which is a strong and thriving economy. And we try to get across to you that not all of us live in the I-95 corridor and have the benefits, the largesse of the federal government, the benefits of all these wonderful things that you have, and I appreciate. We are not here against anyone, and I would appreciate it if we focus on that. Thank you, Madam Speaker.
Majority Leader.
Thank you, Madam Speaker. I want to talk for a second about that argument that was just made, that the disagreement is about the impact on Maryland's economy and our business climate and all of that, because we've heard repeatedly, and we hear every session, this argument that we are somehow, by giving people the ability to take care of their baby or to earn a decent wage, that we are somehow destroying Maryland's economy. So, just to be clear, Maryland has the highest median income of any state in the United States. We are literally the wealthiest state in the US. The most recent data we have on new small business starts, entrepreneurship, Maryland's 10th in the country, far ahead of the promised land of Virginia that some people love to talk about on the floor. And even better, this is a really good one. Because of our commitment to equity, Maryland is #1 in America for black-owned businesses. Our economy is fantastic. Maryland is doing well, and it's doing well under the policies we've implemented over the last few years. And part of the reason it's doing well, frankly, is because of bills like this. Because our workforce matters. We believe that the people that work in a job in this state should be treated well. We believe they should make a living wage. We believe they should be able to take time off for cancer treatment. And you know what that means? It means high quality, educated, experienced workers want to move to Maryland and work in the industries that drive our economy. We hear these arguments over and over and over again. And it's, if you know history, you know it's nothing new. They've been the same arguments for 200 years. When we increase the minimum wage, it's going to destroy our economy. When we implemented paid sick leave, it's going to destroy our economy. Same arguments were made when the Social Security Act was passed. Same arguments were made when child labor was banned. These are the same arguments, and they have never turned out to be true. This bill sets our state on the path towards a very basic premise that we believe people that work in this state should be treated fairly, should have the opportunity to take time off of work to take care of a baby or a loved one or themselves without fear of not being able to put food on the table. It's a pretty straightforward proposition, and I urge the body to vote to override the ill-considered veto of this bill.
Madam Speaker.
Madam Speaker.
Gentlelady from Howard.
Thank you, Madam Speaker. We say that this is a new idea, that it's finally come and we're finally taking care of our workers, our employees. If this were a loan, that I might agree with, but when we passed the Sick and Safe Leave Act, which does a lot of what this one does, I looked at the, excuse me, I'm looking, here we go. The bills that we already have on the books, the things that we have passed and that take care of our employees. So if this is going to do the job, I just wonder what we need to do with all the other bills and all the other laws that we've already put on the books to help our employees, like the Adoption Leave Law, the Deployment Leave Law, Parent Leave Act, Family Military Leave, Emergency Response Leave. I'm sorry, I keep losing it. Come on. I'm only halfway down the list. All right, come on. Down to the right thing. Takes a little away from it if I can't keep going. All right. Sick and Safe Leave Act, the Maryland Flexible Leave Act, Voting Leave, Crime Victim and Witness Leave, civil air patrol leave, Maryland wage and hour law. And as far as caring about our I'll stop there. We already have so many laws on the books to take so good care of our employees. And you say that there has been no results from the laws that we pass, but there have been. They come slowly. Businesses don't go out of business the very next day. They try to make do with it, and eventually they go by the boards, and we are losing more and more small businesses and putting people out of business. Don't say we don't care about our workers, our employees. We have so many laws on the books that do things for employees in every facet of work life that it's hard to argue that there is a glaring need. If we were going to remove a number of these bills, maybe that this would be a better idea to have insurance if everyone wanted to pay for it. But it is not something that is necessary because we haven't taken care of our employees.
Madam Speaker.
Gentleman from Calvert.
Thank you for calling on me, Madam Speaker. I appreciate that. I rise to support the governor's veto. And I do so for a principled reason, and that is I really do believe, Madam Speaker and ladies and gentlemen, that if the folks on the other side of the aisle had an opportunity to spend time with people like my brother, who owns 2 restaurants, or people like me who's self-employed and has been his whole life, and so many other members of our caucus who are self-employed, and saw how difficult it was to manage people in a really small business and actually try to make a living in this state, I do believe that there would be a lot more sympathy for the small business person. Because you see, when you have 15 or more employees with this particular bill, Senate Bill 275, then you are required to participate in this program. That means that if you have 15 employees or more, and 15 employees is a small company, believe me, then you could actually have 2/3 of your employees out for 90 days. I would like for you, on the opposite side of the aisle, to stand in my shoes and try to run my company with 1/3 of the employees, which is the practical impact of the bill that you are passing. If you were to stand in my shoes and you were to actually try to run the company in that way, you would realize that you would be out of business. You would literally be out of business. So there's a principled reason why I rise to support the governor's veto and why you see the minority party, the Republican Party, rise as well. We do so because we know it's not a workable bill. We also do so because we aspire as small business people to one day be medium-sized businesses or big businesses. And we know that in order to compete with them, we need to actually offer very good benefits and pay to employees. But we're not there yet. We're just the small businesses. And if you notice, silent on this bill were the big businesses. They were the ones who were silent because they can afford to absorb these kinds of programs. But the little person, the little guy, little woman who's running a small business of 15 employees or more, it's very, very difficult to ever provide these kinds of benefits and to sustain any kind of business when you're losing 2/3 of your employees. That is a reasonable and a principled approach. And so, Madam Speaker, I rise for all of those reasons because I don't think that when you spend other people's money, you are being virtuous. Thank you.
Gentleman from Caroline.
Thank you, Madam Speaker. And we're going to make the argument that this is the right time because Maryland economy is doing so well. I'm not going to argue that. Overall, the economy is doing well. But it's easy to say, from a representative and somebody who lives in arguably one of the richest counties in the entire country. That's easy to say. Unfortunately, not every county in the state of Maryland, in particular Southern Maryland, Eastern Shore, Western Maryland, we don't have the luxury of having Washington, D.C. right next to us. We don't. Washington, D.C. is siphoning money from 50 states all across the country, and it comes into one place. And Northern Virginia and Montgomery County, Prince George's County, and Howard County are the beneficiaries of that. And everywhere else in the country, the middle class is shrinking, and the rich keep getting richer. And Maryland's no different. And if we're going to say that we're going to pass this bill because Maryland is getting richer, and we're going to ignore these places like the Eastern Shore, that's dangerous, and that's scary, to be quite honest. And I mentioned it before, businesses don't pay taxes. This is a tax. The big businesses are going to do one of two things. They will not absorb the cost. I disagree with the delegate from Southern Maryland. They're going to do one of two things. One, they will reduce payroll by laying people off or not allowing people to work as many hours. They're going to leverage their costs by doing that. Or what they're going to do is they're going to pass that extra cost on to the consumer. And that's what we've been doing for years, and I said it during the debate. We have a whole host of things. Our small businesses in particular are dying of 1,000 cuts. We've mandated higher wages. We've mandated costly environmental mandates. We've expanded unemployment initiatives for people not to work. And every single bill that we pass, most of us will look on it. What's the small business effect? These things compile. They grow. And will this business put people out of business? It may or it may not. But every single bill that we pass that does exactly this, at some point, these people, they can't continue to absorb this. And it will have a meaningful impact on the places that have a shrinking middle class and a growing lower class. You can only charge so much for a cheesesteak sub. You can't. You start charging $25 or $30 for a cheesesteak sub, eventually people aren't going to pay for it, and those businesses will no longer exist. And then those employees don't have a job, and then they're worse off. Thank you.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Would anyone care to change their vote?
Madam Speaker, to explain my vote, please.
From Montgomery, explain your vote.
Thank you, Madam Speaker. I am so proud, again, to vote for this measure. I've been working to get family leave for workers since 1984. And today, I get to not only speak about the importance of supporting families and supporting children and supporting women workers, I actually get to take a step to do that along with the rest of you. So thank you very much, and I'm very proud to vote green again on this measure.
Clerk will take the call. There being 94 votes in the affirmative, 44 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill 275. Said bill is returned to the Senate herewith, having been enacted under Article 2, Section 17 of the Maryland Constitution.
Hearing no objection, the message is adopted. Senate Bill 1, message from the Senate. Clerk will read the message.
Ladies and gentlemen of the House Delegates, the Senate today, notwithstanding the objections of the governor, voted to override the veto on Senate Bill 1. Said bill is sent to you for your consideration.
Hearing no objection, the message is ordered journalized. The clerk will read the bill.
Senate Bill 1, State Finance and Procurement Prevailing Wage, Stop Work Orders.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? Green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Would anyone like to change their vote? Not, the clerk will take the call. There being 96 votes in the affirmative, 41 in the negative, The veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill 1. Said bill is returned to the Senate herewith, having been enacted under Article 2, Section 17 of the Maryland Constitution.
Hearing no objection, the message is adopted.
Madam Speaker.
Oh, gentlelady from Baltimore County.
I'm sorry, Madam Speaker. My finger didn't work on the last vote, and I wanted to be recorded in the green, if that's still possible.
Senate Bill 53. Message from the Senate. Clerk will read the message.
Ladies and gentlemen of the House of Delegates, the Senate today, notwithstanding the objections of the governor, voted to override the veto on Senate Bill 53. Said bill is sent to you for your consideration.
Hearing no objection, the message is ordered generalized. Clerk will read the bill.
Senate Bill 53, Juvenile Law, Child Interrogation Protection Act.
Question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? Recognizing the Minority Leader.
Thank you, Madam Speaker. The bill in front of us, the Juvenile Interrogation Protection Act, and I read Governor Hogan's veto letter, and I think it was pretty well considered because, like so many of us, many of the provisions in the bill, and I'm paraphrasing but half quoting, meant to protect youth are concepts that I, meaning he, and also I, could support. There are a lot of good things to like about the bill, but the community most confronted with some of these issues, many state's attorneys, many individuals in law enforcement who are confronted with these terrible situations, unfortunately, where juveniles are involved sometimes in very serious crimes, believe simply that the bill goes too far and that the bill will ultimately result, whether it's one case, 2 cases, 20 cases, over time, of a very serious juvenile offender being able to get off, quite frankly, from the consequences of a very serious juvenile crime, a violent crime perhaps, because of these provisions, because a confession that they made or statements that they made would be ultimately thrown out by a court because of the further extension of protections that the bill is providing in one section of the bill. And all I can say to that in general is this. If you don't think that crime, the rising of crime, it is not merely a Baltimore City problem and should never be characterized as such. It is a problem that is affecting communities from Ocean City to Oakland and every place in between. And there are an awful lot of reasons for it, and we can debate them for hours and hours, and we should do that perhaps over a cup of coffee or an adult beverage somewhere else other than here. But what we have to start recognizing is crime is on the rise, and it is affecting our communities. It's affecting the perceptions of our communities. It's affecting our children. Many, many juvenile offenders, when they commit crimes, you know who the victims are? Also juveniles. I told the story, unfortunately, of a murder that occurred last year in my hometown of a boy, went to the high school, one of the delegates that's sitting in this room, she well knows, of a boy who was a football star at that school and had a chance to probably be a Division I athlete and had an argument. He was defending his brother. You know, social media is a crazy thing, folks. We need that. Kids today, social media, they're having an argument, a dispute with another individual, another boy from the school, about a girl, I believe. And, you know, back in my day, you would just say that to people and maybe a punch would be thrown or a shove or something would get broken up. But today, that other juvenile, he walked to the school when the school was being let out, and this young boy, 17 years old, whole life ahead of him, came from tough circumstances, came walking out of the school, leave my little brother alone, get the heck out of here, whatever words were spoken. And the other juvenile took a knife and shoved it into his heart. He died almost instantaneously. I know kids, friends with the families of kids who witnessed that, who helped drag that boy's bleeding body back into the high school. That didn't happen in Baltimore. It didn't happen in the most urbanized. It happened in the south end of Cumberland, Maryland, a place that I know well. And the possibility, however attenuated it may be, the possibility that by extending the protections, the interrogation protections within this bill, might ultimately one day prevent one person who committed those types of heinous acts from saying, I get to avoid the consequences because the police officer did something wrong. They didn't conduct my interrogation correctly when I showed up, and it was a 15, 16-year-old juvenile offended that did something horrific. The chance of that happening, we shouldn't countenance. We cannot continue to vilify and keep the pendulum in this state. The pendulum ever moves leftward on criminal justice issues, ever leftward, never toward the middle, never toward pro-law enforcement, never toward more serious and significant penalties, ever leftward. And that pendulum, unfortunately, will eventually swing too far. And I think that that's what the governor's veto of this bill is intended to reflect, and I'll vote to support his veto. Thank you, Madam Speaker.
Gentleman from Baltimore County.
Thank you, Madam Speaker. Members of the House, I think that all we should do when we override this veto is make sure that a young 13-year-old child, before that a police officer takes that child off of his porch, puts him on the curb in handcuffs, takes him in a patrol car with sirens running, and then takes him down to the station, interrogates him for 2 hours using deception and lies to attempt to get a confession out of him or further information. Before a police officer can do that, he ought to actually ask the parents, let the parents know this is happening, or let the child have some legal advice and a lawyer. That's what this bill does. It's Louis Brandeis, Supreme Court Justice, who said, we're better off with letting 10 people out than putting one person who's innocent in jail. And we just want to make sure that these young people are being treated with respect and dignity and given the rights that every one of us should afford. I ask you all to please override the governor's veto on this.
Madam Speaker.
The gentleman from Hartford.
Thank you, Madam Speaker. I rise to support the governor's veto on this bill, and through the debates on second and third reader and Senate version, we talked about a lot of different scenarios. But one scenario that we did not really dive into enough is a scenario that really binds us all. And the one thing that every single member of this body has is schools in their district, and every one of us has is kids in those schools, and every single one of us has is rising violence in those schools in our district. And we'll all go back here in a few days and go back and face those issues. And what this bill does, it makes those schools less safe. And there's evidence of this rising crime, and I'm very grateful for what's happened in Montgomery County. They pulled their school resource officers out, realized that was an issue, and placed them back in. Because we got to make our schools more safe right now, because violence is on the rise in our schools. There's a variety of reasons for it, and we need to work hard as a body to try to solve those issues. We talk a lot about the school to prison pipeline. Well, this very bill is going to broaden significantly that school to prison pipeline. We've passed legislation to reduce the offenses that school resource officers can arrest for in school, and that's good, right? We don't want minor offenses putting kids into the school to prison pipeline. But to the good gentleman from Baltimore County, he just mentioned that, we should give kids the opportunity not to be taken down and be interrogated and all this stuff. Well, in this bill, if I'm a school resource officer and I see an incident of a variety of crimes, they may not even be arrestable offenses. But because I'm not able to ascertain the facts of the matter, I now have to err on the side of public safety, and I have to err on the side of the law, because if I violate this law, I can be fired because of the bills we passed last year. And now every kid involved in the matter, I now have to arrest, take down to the station, and not even the parents, because the parents can't waive the right, wait for the attorney to arrive or to be contacted or to contact the individual. And what's the attorney going to say? And every single attorney in this place knows exactly what the attorney's going to tell them. Don't say anything. Be quiet. So now, because I still don't know the facts, I have to keep them in custody even longer until the attorney can finally have a full debrief with the individuals, with the juveniles, and allow them to waive their rights to tell me that they're innocent. And if this happens on a Friday night at 11 o'clock, well, I'm sorry, if it's school, right? If it happens Friday at 4 p.m. at school, right, and we can't get a hold of an attorney until late Friday night, Saturday morning, or God forbid, Monday morning, that entire time, we have now introduced a kid into the criminal justice system, which is the opposite of everything that we're talking about here in my entire time of the General Assembly. And that's concerning. So what's going to happen is, and this is not an indictment of anybody, this is the natural course of things. If I'm law enforcement, right, I'm a school resource officer, I'm a police officer in the street, I got to err on the side of precaution. And that precaution is going to be, if I see kids in any circumstance that may be illegal, I'm either one, going to let them go, right? Or two, I'm going to round them all up, take them all in, and let the courts sort it out. That's what's going to happen. Why, as a police officer, am I going to risk my livelihood, my job, my reputation, my family, feeding my kids over asking a question of a kid to get to the facts of what could be a violent issue? Unfortunately, that's what this bill does. This bill makes our schools less safe, makes our kids less safe, indoctrinates more kids in the school to prison pipeline. And again, it's good intention. I know we do not want children falsely incriminating themselves. That's a good and noble thing. But this bill's going to have the opposite effect. You're going to have kids who commit crimes getting off on technicalities, and you're going to have kids that never did a thing indoctrinated into the criminal justice system. So for those reasons, I will be voting to support the governor's veto. Thank you.
Madam Speaker.
Gentlemen.
Thank you, Madam Speaker, and I will be brief. I just want to listen to my good colleague speak. The whole point about police officers not knowing what's going on, so they just arrest everyone, that's not the way our criminal laws work. You need reasonable articulable suspicion to start an investigation. And if you want to arrest somebody, you better have probable cause. So that's not going to happen. It shouldn't happen. If it does happen, maybe their job should be at risk. Two, if we're going to rely on the fact that, well, maybe if one of the four people admit that that's their gun, then the rest are going to be let go, not only is that crazy sounding after 20 years of criminal experience, but how bad of a police officer would you have to be just to take somebody's word without collecting other evidence? Know for a fact that if four people are in a car and they're all juveniles and there's one gun, that they're all going to be arrested. It's not we're trying to stop them from being arrested. We're just trying to make sure that they are not tricked, incentivized, or confused into waiving their rights. Because as I said before, a child doesn't have the same brain power as an adult, and it's not fair to be able to trick someone into waiving their rights against self-incrimination. Our country's laws were built on that. Our forefathers knew, because we came from this overpowering throne. That's why we have the 8th Amendment and the 5th Amendment. That's why we backed up the 5th Amendment with Miranda, because people, even though we had the 5th Amendment, still didn't understand. So we required officers to tell them their 5th Amendment rights. This is just one more step to ensure that we protect these individuals who don't have the capacity to protect themselves. So for all those reasons, I ask that you please override this governor's veto.
Okay, the question for the House is, shall the bill pass notwithstanding the objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker. Madam Speaker.
Gentleman to explain his vote.
Thank you, Madam Speaker. I'd just like to remind the body of the implications of this bill not being enacted, and that is the likelihood of a Central Park 5 or an exonerated 5. I would venture to say we've probably had situations like that right here in Maryland, but this is about ensuring that we do not have another situation like we saw where 5 Black and Latino boys were in essence tarnished in the media by someone who was the former occupant of the White House and the standard bearer of the Republican Party. It is to ensure that we do not falsely incarcerate, we don't prosecute kids, And I would disagree with the characterization that this bill goes too far. In fact, I think it doesn't go far enough, because what we know, it is still legal. Maryland is one of many states where it is still legal for police to lie to children who are gullible, who are vulnerable, whose brains are still developing. It is totally legal for them to lie to children and use deceptive tactics during an interrogation in order to get a confession. This bill sets us puts us on the right path, but we must revisit police lying to children and using deceptive tactics during interrogations in order to elicit false confessions that ultimately work against children. So I'll be voting green to override the Governor Hogan's veto, and I hope we'll do more in this space. Thank you.
Explain my vote.
Clerk will call the. Explain your vote.
So I rise in support of the governor's veto because I think we need to do a better job with public safety, and I don't necessarily appreciate our motives being impugned, nor our party's motives being impugned, nor police officers' motives being impugned. Thank you, Madam Speaker.
Clerk will call the roll. There being 93 votes in the affirmative, 44 in the negative, the veto is overridden. Message to the Senate. The clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill 53. Said bill is returned to the Senate herewith, having been enacted under Article 2, Section 17 of the Maryland Constitution.
Hearing no objection, the message is adopted. Senate Bill 259, message from the Senate. Clerk will read the message.
Ladies and gentlemen of the House of Delegates, the Senate today, notwithstanding the objections of the governor, voted to override the veto on Senate Bill 259. Said bill is sent to you for your consideration.
Hearing no objection, the message is ordered journalized. The clerk will read the bill.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill. Senate Bill 259, procurement, prevailing wage, applicability.
Question for the House is, shall the bill pass notwithstanding objections of the Chief Executive? A green vote overrides the governor's veto. 85 votes are needed. A red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Anyone like to change their vote? If not, the clerk will take the call. There being 96 votes in the affirmative, 41 in the negative, the veto is overridden. Message to the Senate. Clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill 259. Said bill is returned to the Senate herewith, having been enacted under Article 2, Section 17 of the Maryland Constitution.
Hearing no objection, the message is adopted. Senate Bill 514, message from the Senate. The clerk will read the message.
Ladies and gentlemen of the House of Delegates, the Senate today, notwithstanding the objections of the governor, voted to override the veto on Senate Bill 514. Said bill is sent to you for your consideration.
Hearing no objection, the message is ordered journalized. The clerk will read the bill.
Senate Bill 514, Transportation Investment Program, MARC Rail Service, Maryland Regional Rail Transformation Act.
Question for the House. Shall the bill pass notwithstanding the objections of the Chief Executive? Green vote overrides the governor's veto. 85 votes are needed. Red vote sustains the veto. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone like to change their vote? If not, the clerk will take the call.
Madam Speaker.
Gentleman from Montgomery.
I was just going to explain my vote, but it's okay if it's gone.
Okay. There being 103 votes in the affirmative, 32 in the negative, the veto is overridden. Message to the Senate. Clerk will read the message.
Ladies and gentlemen of the Senate, the House of Delegates has voted to override the governor's veto of Senate Bill 514. Said bill is returned to the Senate herewith, having been enacted under Article 2, Section 17 of the Maryland Constitution.
Hearing no objection, the message is adopted. Quorum call.
Madam Speaker.
Calendar of third reading, Senate bills number 63. Clerk will read the first bill. Quorum. Call the, take the call. There being 135 members present, House is still in session. Calendar, third reading, Senate Bills number 63. Clerk, read first.
Madam Speaker,
Gentleman from Baltimore County.
our computers, they never mind, they just start working. Thank you.
Clerk will read the bill.
Senate Bill 432, Baltimore County Orphans Court Judges and Surviving Spouses Pensions.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change a vote? If not, the clerk will take the call. There being 132 votes in the affirmative, Senate Bill 432, having received a constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 763, Public Safety and Criminal Procedure, Collection, Reporting, and Publication of Criminal Case and Prosecutorial Information.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, Senate Bill 763, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 861, Public Safety, Firearm Crimes Enforcement Center Offenses and Procedures.
Is on third reading and final passage. Is there any debate? Minority Leader.
Thank you, Madam Speaker. I have an amendment at the desk, 603927/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. This is a omnibus piece of crime legislation that has come over from the Senate and then has been further amended by our colleagues on the House Judiciary Committee. With many things, there are some good things in it, and there's some things in it that, frankly, we, as the members of the minority party here, the law enforcement community that has reached out to many of us, frankly, I don't think that Governor Hogan's office, and I think maybe even more interesting to you, I don't think that the members of the Senate, our colleagues across the hallway, there's a couple things that the House has done to the bill that I don't think they wanted in the bill. And one of the things and the purpose of this amendment is to eliminate what is colloquially, and I hope no one takes offense at this, it's not intended to this, it's just shorthand. They call it the drug dealer loophole. And what that means is that there are a variety of crimes defined as crimes of violence and then another list of very specified crimes. They are all in generally very serious crimes where your penalty or the potentiality of getting into criminal trouble or a criminal charge for engaging in those crimes while using a handgun is increased. And what has happened is that the crime of possession with intent to distribute narcotics has been eliminated from those underlying crimes from which the use of the handgun creates the enhancement. What the amendment simply does is it restores that section of the bill that eliminates them. It's in now section 14 of the code of section 14101A. There is now an exemption that says the use of a firearm in the commission of a felony, and then it says except possession with intent to distribute a controlled dangerous substance. Except. And so I have to ask, I hear so often, and we've had very principled and I think good faith debates about we want to get people using guns off our streets. We want to discourage people from using guns. We want to eliminate the possibility of guns by the bad guys. Do we really think that someone who is possessing with intent to distribute drugs is a good guy and should be able to have a gun? And I want to make very, very clear that what the amendment also does. It says use a firearm does not include the mere possession of a firearm. And that's based upon controlling Maryland law, the Wynn case and the Harris case and their progeny, where our Court of Appeals has said we're not going to apply these enhancers of you used a gun in the commission of the felony or a gun in the commission of the crime of violence simply because a gun may have been in your possession constructively or otherwise. You have to do something with the gun. You have to brandish the gun. You have to use the gun as an implement to achieve your criminal purpose in an active way. And we included that in here. We included that in here because I don't want to falsely ensnare anyone in that enhancement who says, hey, you know, I was convicted of selling drugs. I did have a gun that was in my backpack when the police arrested me, but there's no evidence that I used the gun to help sell the drugs, or I used the gun to facilitate my nefarious acts. That's all the amendment does. That's all the amendment does. The Senate has passed it. The Senate has approved it. The Senate Judicial Proceedings Committee thinks that that's the way that it should be. And I understand that sometimes we think that, the way of the House is the best way. I'm a big believer in the House of Delegates. I, wouldn't have said that 7, 8, 9 years ago that it would have meant so much to me to be a part of this organization and care so much about its traditions and its institution, but it does. But on this one, sometimes when you're the only people saying no, maybe you're not right. Maybe you have to consider the viewpoints of others and suggest that what we're doing by voting against this amendment is saying, I don't want an individual who is using or brandishing a gun in the commission of a felony of being a drug dealer to potentially be additionally penalized. I don't think that's right. I think we should adopt the amendment. If we want to get tough on crime, if we're truly concerned about guns and gun violence, why not use every resource available to us to achieve what should be that bipartisan goal? Thank you, Madam Speaker.
Vice Chair of the committee.
Thank you, Madam Speaker. Colleagues, I'm going to ask you to reject this amendment. Number one, this bill came in with a lot of stuff on it, as the minority leader says, and it came out with a lot of elements stripped, and doing that got it to a unanimous vote in the House Judiciary Committee, with both sides coming together to support this legislation. It is late in the day. It does relate to firearm crimes, and as you can know, that's a very touchy subject. But as to the specific goal that I think is what this amendment is trying to do, it's totally unnecessary. There are crimes of violence stipulated in Maryland law. They include things like armed carjacking, murder, rape. They're supposed to be for the most serious of these crimes. And I have to tell you, I'm having a little bit of deja vu here, because every few years, the minority party, maybe every year, the minority party gets around to asking for toughened penalties, penalty enhancements, because we haven't done enough there to rein in crimes. In 2018, we did quite a bit, and to over my objections, in fact, this body did enhance penalties on repeat violent offenders. You may remember it. It was very controversial. And during that debate, one of the things we did was clarify and try to be very firm and clear about what constitutes a violent crime and what does not. There was a concern at that time that a lot of people were being charged for these crimes of violence and getting a mandatory minimum for mere presence of a firearm, mere presence of a gun. This was a deal from 2018 that was struck, but part of the reason why everybody was okay with this, it's already a mandatory minimum to use a firearm in drug dealing. And so this amendment is totally unnecessary. It doesn't do anything. And as we keep seeing with these repeated attempts to just keep voting and voting and voting on these penalty enhancements, the evidence is showing time and again, these are not the things that are making our communities safer. So the bill before you, without this amendment's going to jeopardize the bill. I will tell you that. We worked very hard to get this unanimous vote here. The bill without this amendment, it's balanced. It does three things. It creates a report to understand where these firearms are coming from that are used in crimes. We've tried to get this done in the past. For whatever reason, people have a problem with creating this report. The second thing it does is it facilitates prosecutors in actually charging these crimes. Again, this was a controversial element for both sides to sit down and accept. We did that. And the third thing is we put in a balanced piece on the other end of this to try and understand what the conditions of corrections and confinement do look like. There's a little bit for everybody to like and a little bit for everybody to not like on this topic. Again, it's a balanced approach. It got us a unanimous vote. If we take this amendment, which again is unnecessary because there's already a 5-year mandatory minimum on firearm crimes, you're going to throw all of the hard work that we put in, again, Republicans and Democrats alike, to get this bill through. So colleagues, please reject this.
Maker of the amendment.
I'm really confused. If it's so unimportant and it's surplusage and it already matters, why is it the most critical thing to passage of the legislation? That makes literally no sense. If you're telling me that we don't need this and it's already covered and it's already in another part of law and it's not that important, it seems to be so important that every time this issue gets debated, the Senate of Maryland, which is not controlled by my party, puts it in the bill. And the House of Maryland, which is not controlled by my party, takes it out of the bill. It doesn't make any sense to me to say, well, it must not be very important. We've already got this covered in another area of law. This is irrelevant. It must be pretty darn relevant because it just keeps happening. And now we're told that if we take it out, the entire bill, which does have some good things in it, frankly, the entire bill will be lost to the political process of Annapolis. It must be pretty darn important. And what I've suggested is, and I'll say it again, there is language in the amendment that comports with Maryland case law. No one is suggesting, my friend from Montgomery County said, we had situations where someone's arrested for dealing drugs and they had mere possession of a handgun. I said that. We don't want that. We do want ones where it is brandished. We do want ones where the handgun is an inherent element of the drug dealing offense, not merely that it's found near the drugs and the drugs are in a high enough quantity to infer that you are a drug dealer, that you have them with the intent to distribute them. That's not what the amendment will do. We very specifically wanted that in there to remove that consideration for communities and individuals who felt troubled by it. That's why we put that in there. I think that at the end of the day, if you're serious about these issues and you're serious about really cracking down on gun crime, then this is an easy thing to do. And with that, Madam Speaker, I'd move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed?
Roll call.
Roll call.
Madam Speaker?
Has everyone recorded the vote? Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? And Senate Bill 861 is on third reading and final passage. Clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 119 votes in the affirmative, Senate Bill 861, having received the constitutional majority, is declared passed.
Madam
The leaders come forward, please.
Madam Speaker.
Madam Speaker.
Let me take those. Do me do the vote changes first. Who's? I don't know who. I'll just go to the left. Yes, right here. No, but
Personal announcement, Madam Speaker, personal announcement.
I'm going to give you
I would do a vote if you have a vote change.
Madam Speaker.
Yes, you're right here.
Thank you. On the vote on Senate Bill 259, I'd like to be recorded in the green. My button didn't work. Thank you.
Any other vote changes? Gentleman from Baltimore County.
On that last bill, 861, my button didn't work, and I'd like to be recorded in the green, please.
Young lady from Baltimore County.
Thank you, Madam Speaker. I can't pull up the vote to check on, make sure that my button did work. On Senate Bill 275 veto override, I want to make sure I'm in the nay.
Gentleman from Prince George's.
Thank you, Madam Speaker. Senate Bill 861, I'd like to be recorded in the green. Thank you.
Any other vote changes?
Yes, Madam Chair. On the
Yes, gentleman
override,
lady from Hartford.
sorry, Senate Bill 514, I was supposed to be in the green.
You're supposed to be. Any other vote changes? Okay. Gentleman from Baltimore County.
Thank you, Madam Speaker. And just real quickly, House, I ask you to help me welcome my wife, Megan, up in the gallery above the speaker, and my daughters, Micah and Dorothy. And if they could stand.
Madam Speaker.
Yes.
Yes. I just want to also acknowledge in the gallery are my sister Jessica, my brother-in-law JR, and our friend Kayron.
Madam Speaker.
Yes. Gentle lady.
Thank you, Madam Speaker. Permission to use delegates' names?
Permission granted.
Thank you. On behalf of the early birthday crew, Delegate Gerald Solomon, Delegate Mary Lehman, and myself, momentarily there will be birthday cake in the lounge. Everyone is invited. Thank you.
Any other announcements? That ends the work at the desk. We'll be coming back at 3:30. Committee announcements. Judiciary.
Thank you, Madam Speaker. Ladies and gentlemen of the House. House Judiciary Committee will vote at 2:45.
Environment and Transportation.
Thank you, Madam Speaker. The Environment and Transportation Committee will vote at 2:15.
Ways and Means.
Thank you, Madam Speaker. The Ways and Means Committee will vote in full committee at 2:15.
Economic Matters.
Thank you, Madam Speaker. Economic Matters Committee will not be voting today. Enjoy your lunch.
Okay. All right. Any caucus announcements? No. Nope. Quorum call before adjournment.
Madam Speaker.
Madam Speaker.
Yes. Majority.
For those of you that want to leave your computers, you're certainly welcome to do so. The chambers will be locked.
Madam Speaker.
Has everyone recorded their presence? Clerk will take the call. There being 136 members present, the House is still in session, recognizing, yes,
Veterans Caucus.
Gentleman from Baltimore County.
Thank you, Madam Speaker. Yesterday, the members would recognize or see that we, from the Veterans Caucus, had left challenge coins on members' desks. If there's anyone that believed they were a member of the caucus but didn't receive one, please let my office know. On that note, I just wanted to, this is the last year of this term, and for the last 7 years I've served as the vice chair, in that 7 years we had one member that has been at the helm, leading us and guiding us with a reputation in the military, a reputation for bearing. We may not always agree and have the same thought process as him, but if permission to use the delegate's name?
Permission granted.
I would like to award him a piece of thanks from the Veterans Caucus. Since I'm in charge, I thought what would he appreciate but also hate at the same time. So I've given out this award, if you would. The Maryland General Assembly Veterans Caucus. To all shall see these presents greetings. Know ye that reposing special trust and confidence and integrity of the abilities of Delegate C.T. Wilson, Chair of the Economic Matters Committee, for his service to the veterans of Maryland and his tenure as Chair of the Veterans Caucus, the Maryland General Assembly. We hereby name you Chair Emeritus of the Veterans Caucus. Don't worry, that does not mean he is the chair. It just means he gets to poke around and talk about the good old days. He was going to do that anyway. So, thank you, Madam Speaker.
All righty. Recognizing the majority leader.
Thank you, Madam Speaker. I move that the House stand adjourned until Saturday, April 9th at 3:30 p.m. So get here at 3:15. Legislative Day, April 2nd.